Please, Lordship.
Yes, please.
Lordship, I beg to mention item number 130.
Item number
130.
130.
130, yes.
Yes.
This matter can be listed up after 2 weeks.
You're the counsel, CGC,
Yes, Lordship.
on the prayer of Mr. Yangarwati, learned CGSC. List the matter after 2 weeks.
Lordship, the same petitioner has also filed another petition that is 75. So if this can also be listed after 2 weeks. Same petitioner, Lordship. Yeah, one.
Yes.
75.
Is it? On the prayer of Mr. Yangarwati, learned CGSC, listed after 2 weeks. Yes.
Much pleasure.
Please, Your Lordship.
Yes, ma'am.
Your Lordship, I beg to mention here in item number 118. Your Lordship, can you list this matter after 2 weeks?
118.
Yes, Your Lordship.
On the prayer made by Miss V. Tere, the learned counsel for the petitioner, listed after 2 weeks.
Give your Lordship.
Lordship, I also beg to mention item number 117. If this matter can be listed. No, yeah.
Yes.
Next. After
Yes.
2 weeks, please.
Okay. On the prayer of Mr. Yangarwati, learned CGSC,
No, Lordship, but it's a private case for the respondent.
Mr. Yangarwati, learned counsel for the
Private respondent.
respondent number 2 and 3,
2 and 3, yes.
listed after 2 weeks.
Much better.
May it please, Lordship.
Yes.
Lordship, I'm back to mention item number 124, Lordship.
Yes.
Lordship, in this case, I'm yet to file affidavit in reply, Lordship. If I may be given some time, Lordship, 2 weeks' time, Lordship.
But why is it listed for hearing?
Lordship, it must be wrongly listed, Lordship. I'm yet to file affidavit in reply, Lordship.
Mr. Moajamir, the learned counsel for the petitioner, submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondent.
Lordship.
Prayer is allowed, listed after 2 weeks in the outer column.
Much pleasure. If I may be allowed to mention item number 126, Lordship, if the matter can be passed over for the day, Lordship. 126.
Not tomorrow. Tomorrow we are having some
Day after tomorrow, in that case, Lordship.
next Monday or Tuesday.
Lordship.
So what is the matter about?
Lordship, it's for regularization, Lordship.
On the prayer of Mr. Moajamir, the learned counsel for the petitioner, listed on 12/9/2022.
Lordship,
2023.
Lordship. I have similar prayer for item number 125 and 116, Lordship.
125. You are the counsel for the petitioner.
Yes, Lordship, in both the matters.
125 and
116, Lordship.
116.
If this matter can be listed after 2 weeks, Lordship. Both the matters, Lordship.
Yes.
Lordship. 125, I'm for the stage, Your Lordship.
Okay. 116 and 120.
5, Lordship.
Okay. After 2 weeks.
Much obliged.
May it please Lordship,
Yes, yes.
I beg to mention for item 123.
Yes, what is your prayer?
Lordship, the Council for Private Respondent is in disposal. Kindly list the matter after 2 weeks.
You're for the private respondent?
Yes, Lordship.
On who, you are a crew?
I am mentioning on his behalf.
Okay. MS Swenso makes a mention on behalf of Mr. or Miss Akril,
Mr.
on behalf of Mr. Akril Chusi, the learned counsel for the private respondent, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
Much obliged, Lordship.
May I please, Your Lordship?
Yes,
I'd like to
please.
mention hearing item 115. And for respondent 5 and 6, Your Lordship, my senior is in disposal if this matter can come up after 2 weeks.
Okay.
No objection, Lord.
Your good name, please?
Wickets or no?
MS Viketsano submits that Mr. A. Jimomi, the learned counsel for the respondent number 5 and 6, is indisposed and therefore seeks adjournment of the case after 2 weeks. Prayer is allowed, listed after 2 weeks. Okay.
May I please, Your Lordship?
Yes,
Lordship, I would like to mention item number 128.
yes, please.
Lordship, due to some emergency situation, my senior counsel is indisposed.
Who is your senior?
Judge Momi.
Okay. Mr. Senso?
Lordship, if the matter can be fixed on Thursday, 4th or 31st.
Makes a mention on behalf of Mr. M.S. Zadzimumi, the learned counsel for the petitioner, and seeks adjournment of the case after a week. Prayer is allowed, listed after a week. Okay.
Oblige, Your Lordship.
May I please, Lordship?
Yes.
Lordship, I beg to mention hearing item number 122, on behalf of M. Solo, counsel for the respondent number 2 and 3. Lordship, the counsel is in disposal. Can you let the matter come up for 1 week?
Mr. So-and-so makes a mention on behalf of Mr. M. Solo, the learned counsel for the respondent, and seeks adjournment of the case after a week. Prayer is allowed, listed accordingly. Okay.
Much obliged. Obliged.
Supplementary clause list for motion, item number 131.
May it please, Your Lordship.
Yes.
The impugned FIR, it's at page 27, 30, page 30 to the petition. And the allegation is that the respondent number 2, who is the complainant in this petition, he invested an amount of 25 lakhs with the company, wherein the petitioner is one of the directors. For this purpose, an agreement was also executed on 9th March 2021.
Yes.
And as per the agreement, checks were issued by the company, not by the petitioner, but by the co-director to the respondent number 2. The agreement also provided that within 2 years, an amount of 35 lakhs would be returned to the respondent number 2. But after the expiry of 2 years, as allegedly the amount has not been returned to the respondent number 2, the FIR has been filed. If Your Lordship may come to the incorporation of the company, which is at page 39 of the petition. The company was
You are challenging the FIR?
FIR, yes.
Mr. So-and-so. The learned counsel for the petitioner. Stop. This application has been filed under section 482 of the Code of Criminal Procedure, 1973, for quashing the FIR number 0016/2022 dated 4/8/2023, registered with the Kohima Police Station for the offense under section 409/417/420/34 IPC, and the consequential GR case number 514/2023, registered and pending before the learned Chief Judicial Magistrate, Dimapur. Issue notice to the respondents.
Yeah, His Lordship. What's about instruction to appear for?
Returnable
2.
within 4 weeks.
Your Lordship, may I interfere? In this regard, I've already filed 2 criminal petitions on the same modus operandi.
I have read.
I may pray that this matter may also be clubbed with those
Yes,
2
yes.
petitions. So, since
Yes, I have read. Mr. Kiangami, the learned PP, appears for the state respondent, and Mr. Fuseko, the learned counsel, appears for the respondent number 2. Since both the respondents are represented, no formal notice need be issued. The learned counsel for the petitioner shall, however, serve requisite copies of the petition to the learned counsel for the respondents within
a week.
within
Today, I also like today.
within in the course of the day. List the present case along with CR,
After a week, after
CR,
CR 10 of 2023 and
CR
criminal
10,
petition
2023 and
11 of 2023.
CR 11, 2023. When are this case listed?
It should be listed this week. So maybe after a week along with these 2 matters.
Okay. You cancel that, list the case returnable after 4 weeks. And list the case along with CR 10, 2023, CR 11, 2023. On the next date fixed, the learned public prosecutor shall produce the relevant case diaries. Okay?
After a week, Your Lordship?
Yes.
Oh, thanks.
Lordship, in the meantime, if I may be allowed to file objection or.
That is.
For motion, item number 32, 132.
May I please, Your Lordship? My lord, this petition is for quashing of the, my lord, criminal proceeding, my lord, pending, my lord, in the sub-urban police station, my lord, Dimapur, my lord. What is in this case, my lord? My lord, respondents are, my lord, the warehouse partners of mine, my lord, because we are the businessmen, my lord, and some agreements are there, my lord, I have annexed, my lord. So, my lord, as per their allegation, my lord, they, my lord, deposited the security money of the, my lord, warehouse, and that has not been returned to them, my lord. And now, my lord, can you turn to page, my lord, 12, my lord, 21 notice was issued to me, my lord, on the basis of, my lord, GDMT, my lord. Case has not been registered, but 41 notice has been issued. Can you turn to page 12, my lord? Page 12, my lord. And now, my lord, kindly turn to page 14, my lord. Page 14, my lord. Memorandum of understanding, my lord. 4 numbers of memorandum of understanding, my lord. And this MOU, my lord, says, my lord, before going to my lord, any proceeding, my lord, they have to settle their my lord dispute through my lord arbitration and conciliation, my lord. That this my lord mentioned in this my lord, my lord, page 16, my lord. Page 16, my lord, para 28, my lord, last para, my lord. Page 16, last para, my lord. Again, my lord, there another my lord, clause, my lord, that any dispute relating to their my lord memorandum, my lord, that this my lord subject to the jurisdiction of my lord Gauhati or Mangalore, my lord. And my lord, now my lord, my contention is that my lord, thus my lord dispute, my lord, purely civil dispute, my lord. Another partner, my lord, already my lord filed my lord civil case, my lord. Can you turn to case, my lord, 30, my lord. Another partner, similar situated, my lord, already initiated, my lord, civil proceeding, my lord, page 30, my lord. I have annexed the notice, my lord. My lord.
You argue your case?
And my lord, kindly, my lord, one judgment, my lord, if my lord civil dispute, my lord, that criminal proceeding is not maintainable, my lord. Kindly, my lord.
Heard, Mr. So-and-so.
I have quoted the judgment also, my lord.
Learned counsel for the petitioner. The present petition has been filed under section 482 of the Code of Criminal Procedure 1973 for quashing the criminal proceedings. There is in fact no criminal proceedings, GDE.
My lord, but my lord, 41 notice already has been issued, my lord. Yeah, APR, my lord. Then unnecessarily, my lord.
It is only in the stage of inquiry.
Yes, my lord. Then, my lord, one.
There is no criminal proceedings.
Yes, my lord. But 41 notice already has been issued. So it is the discretion of the my lord inquiry officer. They may my lord register and put me behind the bars. So that my lord.
We have not come to that stage, Mr. Don't anticipate everything.
Yes, my lord. Then, my lord, record may be confirmed whether my lord, any criminality has been done or not. So that should be decided, my lord.
That is up to the court.
Yes, my lord.
We will call. But
Yes, my lord. And my lord, so my lord, unnecessarily, my lord, I am my lord, on my appearance, my lord, case.
well, what I'm saying is that actually the case is only at the GD stage. No criminal proceeding has been initiated. It is only at the inquiry stage.
My lord, 41 notice has been issued, my lord.
police.
So, my lord, I missed the date also, my lord. So, my lord, there is an apprehension, my lord. Unnecessarily, my lord. Then, my lord, some protection may be given also, my lord. Because, my lord, already missed the date, my lord. I could not appear.
But what did I say, KB? So quashing the criminal proceedings in connection with GDE number 9/2023 dated 12/7/2023 of Suburban Police Station, Dimapur, Nagaland. The case of the petitioner is that the complaint has been lodged by the respondents 2, 3, 4, and 5. Against the petitioner for disputes arising in relation to the memorandum of understanding which was executed between the petitioner and the respondents on different dates. And consequent to which the notice under Section 41 within Clause A, CRPC, in connection with GDE number 09/2023, dated 12/7/2023, has been issued to the petitioner. Stop. It is the case of the petitioner that due to illness, he has not been able to appear before the Suburban Police Station, before the inquiry officer, Suburban Police Station, in connection with the notice, which is dated 1/8/2023. It is further the case of the petitioner that the memorandum of, it is further the case, new para, okay? It is further the case of the petitioner that the memorandum of understanding dated 8/9/2021 was executed at Mangaldoy, District Assam, between the petitioner and the respondent number 2, by which the respondent number 2 was appointed as warehouse partner for Dimapur Mukukchong Zinabuto in the state of Nagaland, with effect from 8/9/2021, for all kinds of LED TV under the brand name within apostrophe IM all capital IMEE-LED TV close apostrophe, manufactured and brand owned by Parish Gadgets Private Limited. So also, the agreement dated 28/6/2021 was executed between the petitioner and the respondent number 3 at Mangaldoy, by which the petitioner, by which the respondent number 3 was appointed as the warehouse partner for Dimapur in the state of Nagaland with effect from 28/6/2023 for dealing in all kinds of electrical products and appliances under the brand name within apostrophe Surya Life, SURYALIFE, manufactured and brand owned by GSEC, all capital, Industries Private Limited. So also, the MOU dated 21/5/2021 was executed between the petitioner and the respondent number 4 at Mangaldoy, by which the respondent number 4 was appointed as stockist point and warehouse partner for Oka in the state of Nagaland with effect from 21/5/2021 for all kinds of electrical products and appliances under the brand name within apostrophe Omega, manufactured and brand owned by Omega Appliances Private Limited. So also, the memorandum of understanding dated 7/8/2021 was executed between the petitioner and the respondent number 5 at Mangaldoy, by which the respondent number 5 was appointed as warehouse partner for Dimapur in the state of Nagaland with effect from 7/8/2021 for all kinds of electrical products and appliances under the brand name within apostrophe IMEE, manufactured and brand owned by Parish Gadgets Private Limited. Stop. It is the case of the petitioner that the memorandum of understanding executed with all the respondents contains a stipulation that in the event of any dispute or differences between the first party, between the petitioner and the respondents, arising out of, in relation to, in connection with, or touching upon the subject matter of this agreement, including any dispute or differences arising after the termination of this agreement, including the termination of the terms and conditions of any invoice purchased by the second party during or after termination of this agreement shall be referred to arbitration in accordance with Arbitration and Conciliation Act 1996. 1996. 1996. 1996, and the arbitrator for the arbitration proceedings will be appointed by the petitioner, and the venue of the arbitration will be at Mangaldoy jurisdiction only. Stop. It is further submitted that the MOU further contains a stipulation that all disputes are subjected to Mangaldoy and Gauhati jurisdiction only, and no other jurisdiction in India. The Learned Council therefore submits that in view of the MOU executed between the petitioner and the respondents, the complaint could not have been registered with the suburban police station and the first notice under section 41 SCRPC issued to the petitioner. Being aggrieved with the registration of GDE number 9/2023 dated 12/7/2023 and the first notice issued under section 41 within bracket ACRPC, the petitioner is before this court. So, issue notice to the respondents, returnable within 4 weeks. Since the state respondents are represented by MS Mary, the learned public prosecutor, no formal notice need be issued. The learned counsel for the petitioner shall, however, serve requisite copies of the petition to the learned PP when, in the course,
Within 3 days, my lord.
within a period of 3 days from today, insofar as the respondent number 2, 3, and 4 are concerned. The learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within a period of
4 days, my lord.
within a period of 4 days from today. In the interim, it is ordered that the GDA number 9/2023 dated 12/7/2023 No. In the interim, it is ordered that the inquiry in connection with Suburban Police Station GDE number 9/2023 dated 12/7/2023 and the first notice issued under section 41 ACRPC shall remain suspended till the next returnable date, listed after 4 weeks.
I love that.
For motion, item numbers 133 and 134.
May I please, Your Lordship?
All right.
My Lord, 8 petitioners have already withdrawn and 3 more petitioners are applying for withdrawing from the case, Lordship. But in the meantime, my lord, since the department concerned have filed a preliminary objection, my lord can hear the preliminary objection. Okay. It's your objection.
What is your affidavit?
Lordship, as per order.
No piecemeal hearing, no piecemeal hearing.
Lordship, I have filed my affidavit.
Yes,
Lordship.
preliminary objection on the mentionability.
Lordship.
On the merit also you filed. No, you were directed to file affidavit on 17/8/2023.
Lordship.
So you file your affidavit, we'll go for complete hearing. No piecemeal hearing. On this IA, I heard Mr. Joshua Shaki, the learned counsel for the applicant.
Ma'am.
Stop. This application has been filed. Praying for withdrawals of the name of the petitioner number 1, 2, and 16
My lord.
in WPC 156/2023. Prayer is allowed. The petitioner number 1, 3, the name of the petitioner 1, 3, and 16, 1, 2, and 16 shall be deleted from the writ petition. Registry to take steps. Okay. I opposed. You file your affidavit, we'll hear you, we'll file your
Short date
affidavit.
may be given, Lordship.
Why are you just extending the date because of not complying with the court's order? We'll give you a week's time.
Lordship.
You are the counsel for the
Respondent number 3, 4, 5, 6, Lordship.
3, 4, 5, 6.
Lordship.
MS Apila, Samtam, the learned counsel for the respondent number 3, 4, 5, and 6 shall file the affidavit on behalf of the state, on behalf of the said respondents as ordered by this court on 17/8/2023. Listed up their work.
Lordship, lordship.
For admission, item number 1.
May it please your lordship.
Yes, please.
My lord, in this case also, my learned friend for the respondent, the private respondent,
Yes.
has filed a preliminary objection instead of affidavit in opposition. However, since he has raised a preliminary objection,
What is your case? What is your case?
lordship, in violation of the section 2G of the Village Councils Act 1978,
What is 2G?
2G, lordship, without the consent of the village council, the village land cannot be sold.
No immovable properties can be transferred.
Yes, no immovable property can be transferred. 15G, lordship, my apologies.
15G.
Now, my lord, here in this case, the transaction took place between the present petitioner's village member, who is also one of the petitioners, and the private respondent, without the knowledge of the village council, and the private respondent is from other village, lordship. And in the earlier occasions also, the two villages, since they had some dispute, though they are brother villages, they have all returned all the lands that they have sold to each other, except this is the only land that was left out, lordship. So-
Mr. Lima, you file your affidavit. Okay?
Lordship, I've already.
No, yeah, your maintainability, no, let us not go for piecemeal hearing, let us go for full hearing. You file your affidavit. You are the counsel for the?
Respondent number 1 and 2.
Respondent one. Mr. Lima, the learned counsel for the respondent number 1 and 2. shall file comprehensive affidavit on behalf of the state respondents, listed after 2 weeks.
My lord, I have a request.
Yes, please.
I may also be allowed to implicate the president of Tikir Tribal Council in person, lordship.
Okay. What is the necessity, Mr. Joshua?
Lordship, the money, the Tikir Tribal Council took up the matter and 50,000 fine was imposed upon the present petitioner's village. The amount was paid and the president in person has handed over, apparently he has handed over the money to the private respondent.
Mr. Joshua Shakti, the learned counsel for the petitioner, is also allowed to implicate the president of
Tikir Tribal Council.
Tikir Tribal Council in person,
My lord.
correct?
Yes, lordship.
As the respondent number,
My lord. Respondent number 4, lordship.
as the respondent number 4. Yes. Okay.
Bless you, lordship.
For admission, item number 2.
Your Lordship, on behalf of Thibapon, kindly let the matter come up after 2 weeks.
MS AIME makes a mention on behalf of Mr. E. Thibapon, the learned government advocate, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
For admission, item number 3.
Please, Your Lordship, I'm mentioning on behalf of Miss Lucino. Lordship, she is indisposed, Your Lordship, so if this matter can come up after 3 weeks.
MS so makes a mention on behalf of MS Lucino, the learned counsel for the petitioner,
Yes, Your Lordship,
and seeks adjournment of the case after 2 weeks.
3 weeks.
After 2 weeks. After 2 weeks. Prayer is allowed, listed after 2 weeks. Okay?
For admission, item number 4.
May I please, Your Lordship, kindly grant 2 weeks time to file a reply to the affidavit filed by respondent 1 and 2.
State by the
State,
state.
Your Lordship.
MS so the learned counsel for the petitioner, submits that she may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 2 weeks.
God bless you.
For admission, item number 5.
Please, Your Lordship, pleadings are complete here, so let the matter be listed for hearing.
None appears for the petitioner. It is submitted by MS AIME, the learned government advocate, that pleadings are completed, and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
For admission, item number 6 to 46.
What is this matter?
It's about damage compensation.
Compensation.
Okay. That's straight. Zenabuto Chakabama.
Yes, lordship.
So what is the latest position? What is the latest position with the litigation in the Honorable Delhi High Court?
It is still pending before the Honorable Delhi High Court. Yet in PIL 9, 2019, regarding CPO, PIL, there is a positive move. That is how, may I pray, that Honorable Court may be pleased to pass the similar order, which was passed on.
The liability is not cast on you, no? So you're very eager
Yes, Your Lordship.
to have the disposal. But that in that case, actually, the case which was pending before the Delhi High Court was
There are
never considered.
correspondences, Your Lordship, from Ministry of.
Mr. Joshua, I would like to let the Delhi High Court first dispose of the matter. Not before that. Or else you can take a chance before any other court.
In this case, I cannot insist, lordship, because though not connected, it was directly and indirectly dragged into the arbitration issue.
Now, and actually your subject matter
My lord.
is now before the Delhi High Court.
Lordship, hopefully, as my learned friend, Mr. L.T. Sanktam, the additional AG has submitted, if there is a positive outcome in the case of the PIL 9 of 2019, and that is taken care of, then it is the same stretch of road.
No. That in that case, actually, like the case which was pending before the Delhi High Court was never brought to the notice of the court. I was I was one of the judges there.
I believe it was brought, Lordship.
No, it was not brought. Only the arbitration.
Yes, Lord.
Only the arbitration was
No,
brought.
my lord, my lord.
But the case which was pending before the Delhi High Court was never brought.
But
So
all those issues are connected with the case which is now before the Delhi
it
High
may
Court.
not be proper for me to just proceed with the case when the matter is still pending before the Delhi High Court.
Right, my lord, then we'll
Okay.
wait for a positive outcome in 9 of 19 PIL, Lordship, the case.
9 of PIL 9 of 19, it is an appeal.
No,
Well,
PIL.
What is PIL 9 of 19?
2000.
That was before me and before my Lord Justice Sato and me.
Yes, Lordship. So, Lordship, same stretch of road, if they are considered, then we can also ask for the same yardstick, Lordship.
But that's why I'm saying in that PIL, the matter which was pending before the Delhi High Court was never brought to the notice of the court. So it may also not be proper for me to just proceed with the case when the matter is still pending. When same subject matter is pending before the Delhi High Court. So we'll list it after some time.
Sure. After 3 weeks, my lord, then.
Yes, list it after 3 weeks.
Bless you, Lord.
For inclusion, item number 47.
Item number 47. Oh, gone back there.
Please, Your Lordship.
Yes.
Your Lordship, here I am informed that the file cannot be traced, Your Lordship, so I have to serve a fresh notice, Your Lordship. So another 3 weeks will be granted, so that I will send.
47.
Yeah, 47, Your Lordship.
This is
I was actually instructed to.
CGSC.
No, Your Lordship, here they actually DC has issued the domicile certificate. So to authenticate that one, Your Lordship. However, when I sought for instruction, they informed me that they couldn't able to trace the file. Maybe because they were reshuffling, Your Lordship. So maybe during that time the file might have got misplaced. So, Your Lordship, I have
You are the counsel for which respondent?
Respondent 3.
Respondent 3. What is the case about?
Lordship,
Why was the direction given to you? What direction was given to you?
No, Your Lordship.
By which order?
No, Your Lordship, they are collecting the certificate. It's not the certificate issued by the DC, that is domicile certificate, residency certificate. It is being issued by the DC, but the thing is that it is being challenged, Your Lordship, that it is fact. So we have to ascertain whether that certificate is being issued, Your Lordship.
By which order you were given that direction?
Even by the last order, Your Lordship.
By the last order. No, Ms. Levika is allowed 2 weeks' time to file affidavit in opposition on
Yes,
behalf
Your
of respondent number
Yes, Your
3.
Lordship. That is the thing only, Your Lordship. We are supposed to file a affidavit.
So file it.
Your Lordship, so the thing is that they could not able to trace the copy of the writ petition also, Your Lordship. So I have to again furnish a fresh writ petition to them.
Okay. MS Levika, the learned government advocate, 6 for 2 weeks' time to file affidavit in opposition on behalf of the respondent number 3. Prayer is allowed, listed after 2 weeks. Okay.
Lordship, that's interim.
Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Bless you, Lord.
For admission, item number 48.
None appears for the parties. Listed after 4 weeks.
For revision, item numbers 49 to 51.
Yes, Lordship.
Yes, Mr.
My name is Sean as counsel for the Nagaland Local Lordship.
Nagaland Lok Ayukta.
Yes, Lordship. I am no more the counsel for the local. So my name will be deleted, Lordship.
Who is for the Nagaland Lok Ayukta, Mr. TB?
Lordship, only on the case-to-case basis, yes.
Case to case basis, yes.
My name will be deleted. The notice will be issued to the local Lordship.
Lordship, on last occasion on 11/4/2023, Lordship was pleased to issue the notice of the Ayukta.
11-4.
11/4/2023.
Whether it is a respondent number 5 or 4?
Respondent number 4.
And in 11-4, it is written respondent number 5.
Lordship, there are 3 cases under this matter. Maybe,
No, it's same.
the only cases that.
What is your case, Limauban?
Lordship, here, Lordship, the present petitioner, they were initially appointed as a work-class employee. Their service were regularized. So the issue came up, their services were regularized without obtaining the approval of the state government. So the matter was referred to the Nagaland Local Vigilance Commission. So Lordship, it is not a current practice, it is an irregular exercise. So the CAG is not attracted in this case.
Lok Ayukta has recommended cancellation of your regularization.
On 2 counts, they have violated rules. Firstly, he has the jurisdiction to make any recommendation. He has recommended to cancel our regulation order in the advertised terms. And one thing, Lordship, it is an irregular exercise. Declaring my service without obtaining of the state government.
Then there is a stay operating in your favor.
Exactly. So, Lordship, an interim protection is there.
Okay. Who's for the state? What is the role of the state?
Worship, the state government, they have recommended to the Vigilance Commission initially.
Have you filed your affidavit?
Yes,
Ma'am?
Lordship.
Why Office Note 18/7/2023, it is observed that pending disposal of WA 27/2022, this case was kept in abeyance. Okay. With the disposal of the said WA, the same is listed. Okay, okay. So in fact, this case was also kept in abeyance, awaiting the result of WA.
No, Lordship, no vigil is pending in this issue.
The Office Note states.
Maybe they didn't, registry, they didn't get, given a wrong remarks.
Mr. Limawaba, in all the cases, no?
You know the case.
The learned counsel for the petitioner. And MS Mary, the learned senior government advocate for the state respondent number 1, 2, and 3. None appears for the respondent number 4. Stop from the orders passed by this court. It is seen that on different dates, notice has been issued to the respondent number 4 to enter appearance. However, till date, there is no representation on behalf of the respondent number 4. Stop. It is made clear that if on the next date, there is no representation on behalf of the respondent number 4, the case shall proceed without the participation of the respondent number 4 in the case. Stop. A copy of this order may be issued to the Nagaland Lok Ayukta, who is the respondent number 4 in the present case. Stop. The name of Mr. N. Muzui as the counsel for the Nagaland Lok Ayukta shall be struck off. Stop. Registry to take necessary action.
Resolution, item numbers 52 to 56.
Yes, Mr. Supamwati. This is, what is this? IA. Oh. What is your IA first?
So, Lordship, the IA has been filed by the respondents seeking for condemnation of delay, Your Lordship, in the review petition.
Oh, this is filed by the state.
Filed by the state. Your Lordship, I would like to mention on behalf of additional AG in teams of Lordship. Lordship, I've been instructed to mix the matter after 2 weeks. Lordship, may please to grant 2 weeks that.
Yes, Lord.
On the prayer of the learned government advocate, list the case after 2 weeks.
Okay, Lordship.
Resolution, item number 67.
Yes, what is the case about?
My lord, this is about one police constable died way back in 1984. But the family, they were not granted any pension. That is the whole issue.
What is his entitlement to pension?
My lord,
What is his entitlement to pension?
the family.
What is the entitlement of the deceased police constable? Why is he entitled?
My lord, he was a regular employee.
Yes, regular employees
So,
serving for
3 years, I think. Yes. 82 appointment. He died in 1984.
82 appointment, died in 1984.
Yes. While on duty.
Yes,
While on duty.
is that government employee entitled to pension?
Your Lordship, here all pensionary benefits were given to the nominee. The nominee is the mother of the deceased, not the wife. Here, petitioner is the wife, and she's claiming for the pensionary benefits.
Yes,
Mother.
the mother of the deceased government servant has been given the pensionary benefits.
No, that is not the correct.
No, Your Lordship, it has been given except for the family pension. Otherwise, all other beneficiaries have been given like that gratuity.
Who is the petitioner, by the way? Who is the petitioner?
The wife.
Who is the nominee?
No.
You first prove that.
No, the family pension goes by the rule. That is first is the spouse in the children. Not by nomination, not even by succession.
No, but if the nominee is not the wife, then
Nominee is for family benefit or PBF. Pension is not as per the nomination. It is as per the rule.
yes, AG.
Mother, AG, the department has written one letter on 7 June 2023 because pension documents were furnished to the AG. Yes, if
Kindly refer to the letter dated 6/6/2023.
how many look at her? 7 June, signed on 6/6/2023. 7 June. Yes.
Lordship, gratuity has already been authorized to the eligible nominee at the time of the pension settlement.
What about the family pension? What is your stand?
Okay, the office of the office has not received any letter for inclusion of nominee, nor any order for payment of extraordinary pension, ex gratia benefits in respect of the petitioner. So, on the receipt of the document in complete shape from the pension sanction authority, head of department, the case will be settled.
Yes, madam, if the
Your Lordship, in my affidavit, paragraph 5, page 3, here I have mentioned that with regard to ex gratia payment and extraordinary family pension, the matter has been put up before the government, and necessary action decision will be taken up as per the advice received. So, Your Lordship, this is still awaited.
waiting, stop.
From the respondent DNA, that is respondent
awaiting necessary instructions from the government. List the case after 3 weeks. Okay. Okay, after 2 weeks.
Much obliged.
For admission, item number 58.
Yes, Mr. Tongpong.
Please, Your Lordship.
Yes.
Your Lordship, I'm here to file my reply to the affidavit filed by respondent number 3. So I'm going to give him 2 weeks time.
MS V. Cherry, the learned counsel for the petitioner, 6 for 3 weeks' time, to file affidavit in reply to the affidavit in opposition filed by the respondent number 3. Prayer is allowed, listed after 3 weeks.
Your Lordship, there's an interim, so kindly.
Stop. The interim order passed earlier shall continue till the next returnable date.
Bless you, Lordship.
For admission, item number 59.
May it please, Your Lordship.
Yes.
Your Lordship, I'm here to file my affidavit in reply, hence kindly allow 3 weeks time.
The learned counsel for the petitioner, 6 for 2 weeks' time, to file affidavit in reply. Prayer is allowed, listed after 2 weeks.
For admission, item number 60.
Yes.
Last time, on last occasion, the learned CGC, who is a people respondent, yes, made a submission that, yes, send his affidavit for meeting.
Mr. Zatan Muli. What to do?
He has not struck a provision to us, so most probably he has not filed that.
I think we have to pass some very strict orders against this CGSC. Yes, Zatan Muli. Two weeks' time is granted to the learned CGSC for filing the affidavit in opposition.
Your Lordship, does not come under the ministry.
Last time, Mr. Zatan Muli, CGSC, has actually made a submission stating that actually he has sent the affidavit for waiting.
Yeah, that I have no problem. Otherwise,
Okay.
For admission, item number 60. Sorry, item number 61.
Yes, Mr. Yanawati, your case.
Lordship, for some instruction, Lordship, 3 weeks time will be granted, Lordship.
You have for respondent number?
For 80, Lordship. Respondent number 4.
Okay.
Lordship, this is basically a case, Lordship, where the petitioner is asking for nomination as a nominee in the pension. All the issue is with the government. So unless the government nominates,
Have you taken steps with the government?
yes. But
Yes.
the government is writing to us. Because we have more role to play, Lordship, as far as the nominee is concerned. Lordship, the petitioner is so wide. But the pressure has been paid to the children. You see, that's the way. Now, as per the pension rule, it is the first person who has to get a pension is the wife.
Why actually your name was not in the nominee and why you have not been given the pension? What is the reason?
He will succeed his certificate without the knowledge of the wife. The shown as divorced.
Was divorced.
Yes, by the family members of the petitioner's husband. That's how they completion the roles. Now, as far as the role of the EG is concerned, Lordship,
So you have to first actually sort that out.
it has already been sorted out.
Sorted out by whom? Sorted out by the court. If there is a dispute regarding a divorce.
Sir, let the AG find the affidavit and after that, that's the step. So we will take a question.
Okay, Mr. Mazui, you please bring the son of AG before this court.
Please submit. Please.
Mr. N. Mazui,
It's a long that it gets measured to
the
the
Learned Standing Council for the respondent number 4 is allowed 2 weeks' time to place the necessary instructions before this court. Prayer is allowed, listed after 2 weeks.
For admission, item number 62.
Next, Lordship.
Yes.
Lordship, kindly bring me one more time, Lordship. I'm yet to file the affidavit for number 7.
You are for?
I'm for the private respondents 3 to 8.
Lordship.
3 to 8.
3 to 8.
Lordship, I have a prayer.
Yes, please.
Lordship, during the pendency of this case, the respondents, especially the private respondents, are taking undue advantage. They're taking up developmental activities in the disputed land. So, Lordship.
What is the interim order? Is there any interim?
Yes, my Lord.
Let's see
There's
that.
an interim order dated 39/2022.
You should have brought it by way of an application. 39.
2022, Lordship.
39/2022.
Lordship, in the interim.
39/2022. In the.
Yes, Lordship, in the batch 3 of the order. In the interim order dated 6/9/2022, passed by the Deputy Commissioner, Democracy.
And what was the impugn order? What was the impugn order?
The order passed by the Deputy Commissioner was directing the parties to a civil court.
Okay.
Whereas I've challenged this order because the DC Dimapur, who assumes the power of a revenue court, has not exercised its power as per the Assam Land Law and Revenue Regulation 1886. More particularly, the relevant portions are in 154 and 167. So in view of that, I challenged this order. However, Lordship, in this complaint itself, there is a restraining order by this revenue court that the parties should maintain status quo. I have even enclosed that order in this petition, Lordship.
Where is that?
Page 24, Lordship. It is the initial order passed by the revenue court, Lordship.
And this is still in operation?
Lordship, in view of the suspension of this order dated 29/2022, this should come into operation, Lordship, because the matter is still.
In view of the suspension of which order? 16/9/2022?
Yes, my Lord, yes, my Lord.
Which page? Restraining order?
Yes, my Lord, it's in page 29 of the petition, 24 of the petition. Operative part is in the last portion, Lordship. So, in this regard, Lordship, the parties should maintain status quo until this matter is resolved by appropriate forum. But the respondents are taking undue advantage of the order that is 16/9/2022 However, that has been still suspended by this honorable court, Lordship. So that's my humble prayer, Lordship.
Yes, Mr. Fusako, please tell your respondents not to undertake any developmental activities, lest this court may have to come down heavily.
Lordship.
There is an order of this court.
Lordship. After making mistakes, to already
Yes.
down the court.
Don't tell them to waste money,
Lordship.
because if they are in the wrong, we may even direct dismantling whatever structure has been set up.
Lordship.
Mr.
Lordship, I'm for responding 1 and 2. Lordship.
You have filed your affidavit.
No, Lordship. No, Lordship.
1, 2, and 7.
1 and 2. I'm for
No, 1,
Yes,
7.
7. 7 also yet to file. 3 to 8 with the.
Who are the respondents who are undertaking construction?
Lordship, 3 to 8. Lordship.
3 to 8.
Yes, these are the private respondents, Lordship.
Third, Mr. So-and-so. Imkong.
Aliba Uzukum, Lordship.
I'm sorry, Aliba Uzukum, the learned counsel for the petitioner. And Mr. V. Jimomi, the learned government advocate for the state respondent number 1 and 2. Stop. Also heard Mr. Fuseko, the learned counsel for the respondent number 3 to 8.
Lordship.
Mr. V. Jimomi, the learned government advocate for the respondent number 1 and 2, as well as Mr. Fuseko, the learned counsel for the respondent number 7, 6 for 3 weeks' time to file the respective affidavit in opposition. Stop. Mr. Newpara, Mr. Imkong Ozukam.
Aliba Uzukum, Lordship.
Aliba Ozukam.
Yes.
The learned counsel for the petitioner submits that despite the interim order dated 39/2022 passed by this court, suspending the impugned order dated 16/9/2022 passed by the Deputy Commissioner. The respondent number 3 to 8 are undertaking construction on the disputed land. Mr. Imkong has also referred to the order dated, which is this date, the DC's order, to the order dated 23/11/2017.
Yes, my lord.
Passed by the Deputy Commissioner, Dimapur, by which the parties were directed to maintain status quo on the disputed land. Mr. Imkong, Mr. Aliba Uzakam, learned counsel for the petitioner submits that despite the order dated 39/2022 and the order passed by this court and the order dated 23/11/2017 passed by the Deputy Commissioner Dimapur, the respondent number 3 to 8 are continuing to undertake developmental activities on the land in question. Stop. The respondent number 3 to 8 are directed to comply with the order dated 39/2022 passed by this court. And to deter from undertaking any developmental activities on the land in question. Stop. The Deputy Commissioner Dimapur shall depute the revenue officer
Yes, ma'am.
to carry out necessary verification and to submit report if respondent number 3 to 8 are undertaking any construction / developmental activities on the disputed land in question. Stop. Listed after 2 weeks. A copy of this order shall be furnished to Mr. V. Jamabi, the learned government advocate, in the course of the day. Yes.
Much obliged.
Just 2 minutes break, please.
For admission, item numbers 63 to 74.
Yes.
May I please, Lordship?
Yes.
Lordship, I'm for the petitioner from 68 to 74.
68 to 60,
68 to 74, Lordship.
68
68 to
to
74.
74.
I'm for
And
petitioner.
63, Mr. City?
63 to 67. I am
63.
for the petitioner.
Yes.
Lordship, I'm yet to file my reply. Lordship, kindly give me 3 weeks time, Lordship, to file my reply.
Is it analogous?
Yes.
And City, no need to file.
So far as 63 to 67 is concerned, dating have been completed.
Okay.
It's waiting for hearing.
So expedite.
Lordship.
Okay. 67 to 68 to
68 to 74.
74. Mr. Fuseko, the learned counsel for the petitioner. For, ma'am, 68, you give read petition na, for WPC so-and-so to WPC so-and-so. 6 for 2 weeks time.
Lordship. 3 weeks, Lordship.
It will be 2 weeks. Lord.
6 for 2 weeks time.
Since others have already been.
Yes, to file affidavit in reply to the affidavit in opposition filed by the state respondents.
Lordship.
Prayer is allowed, listed after 2 weeks. Expedite.
Lordship.
Yes.
For admission, item number 76.
What about 75? Oh,
75 was mentioned.
mentioned?
It was not always with one
Okay.
hearing item.
Okay, 76. Yes, Mr. City?
Respondents have filed counter.
Yes.
And I would like to file a short reply.
Okay.
And in the reply, I would like to incorporate about the duties we have performed during COVID time. We are collecting some.
What is the matter, Mr. City?
The matter is our cases were supposed to be regularized during the COVID time. But then suddenly they have included our cost to be advertised.
You are the doctors who are doing
Ayush doctors. And that has been challenged. And the interim models have been passed. And the respondents have filed counter, and we would like to file a short reply, Lordship. 3 weeks time may be allowed, Lordship.
Mr. C.T. Jamir, the learned senior counsel, submits that he may be allowed 3 weeks time to file reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 3 weeks.
Interim may be continued.
Stop. The interim order passed earlier shall continue till the next returnable date. Yes, please.
For admission, item number 77.
Yes, Mr. C.T.
Your Lordship may kindly see order dated 18/7/2023.
Yes, what about the developmental fund?
Your Lordship, I have the information yesterday from the Deputy Commissioner, Kalisa. They had a meeting because this matter relates to disbursement of RT Rural Development Fund. They had a meeting last week and along with the block development officer, and he has sorted out the names, job holders' name, and then it has to put to the bank. Payment has to be through the bank only.
Who has to draw the bank? Who has to draw the payment from the bank? Whether the petitioners.
No, the authority, that means the Department of Rural Development, has to proceed it. Job holders has been identified. Those who has got a job holders card has been identified, and the process is on. So, Your Lordship, let this matter will come up with 3 weeks.
Yes. But I think you are actually coming up with these submissions every now and then.
Yes, Lordship.
No.
I think this should
What's
not.
the identification of the job holders? Identification of the job card holders in the village has been done. Has been done.
That was the same submission earlier on the earlier occasions also. Therefore,
Now the process is when job holders card has to be processed to the bank. That is the thing. This is the process. It is not that it has to be expressed like that.
So identification of job card holders, this has been done.
It has been done.
Then what is the next step?
Next step has to be job holders card, bank account has to be identified to the bank. To the bank.
You're making it more complicated.
No, Lordship, it is done in that way, this stage. So my brain.
No, I still didn't get you. The bank has to do what?
The bank has to.
This job card holders, the account, the bank account has to be submitted?
No, Lordship, it is like this. Those who are job holders card.
They have been identified. Yes.
It has been done. Now, it has to put to the bank, and the bank has to identify the bank account.
Bank has to identify the bank account of the job card holders.
Job card holders in the bank. So, process is like that. So,
on the last occasions also, they have met a similar where that the verification is on. So if the verification is done, then the only thing left is to make the payment.
Is it the job of the bank to identify the account of the job card holders?
No.
Then you are making that submission?
Job card holders should have a bank account. Those who are holding the job card in the RD department should have a bank account. That is the process, Your Lordship. Because money is dispersed to bank account only. That is the thing. But then it is almost 90% has been done. Because we have identified those who are the job holders, job card holders.
By reading the last order, Lordship will find time period was also given in the last two paragraphs, based on the submissions made by the Council for the State. It is 7/2023.
Yes, it was in the.
Last two paragraphs will be relevant.
This is what fund?
VTP.
VDP?
Yes.
Mr. Moa, I think you will have to seriously instruct the Deputy Commissioner, or else we will consider asking the Deputy Commissioner to come before the court and explain. That's why we will not pass any order against the Deputy Commissioner this time. But if actually the Deputy Commissioner sees over the matter and you are asked to make submission, always stating that the modalities are being completed to make the payment, and nothing is finalizing, I think.
Last time what happened, Your Lordship, there was a landslide. There was landslide, road communication was not there. So that way, there were problems. But now it was somehow cleared, so the meeting was held, job card holders were identified.
And the process is on to make the payment.
Yeah.
Job card holders, they have been identified and the process is on to make the payment
Take the payment.
to the
Through
job card
bank.
holders,
Through
through the bank.
Through bank.
Third, Mr. C.T. Jamil, the learned senior counsel for the petitioner, assisted by Miss M.S. So-and-so, learned counsel, learned advocate. Also heard Mr. Im Kong Muaing Chen, the learned senior government advocate for the state respondents. This is a case where the government has been seeking time by making a submission that steps are being taken to pay the VDB fund to the beneficiaries. However, despite the various orders passed by this court, directing the Deputy Commissioner to complete the disbursement of funds to the petitioner, no step has been taken to make the final payment, to make the payment to the beneficiaries. Stop. Today, when the matter is listed, Mr. Moin Chen, the learned senior government advocate, submits that identification of the job card holders has been done. And the Deputy Commissioner and not the Deputy Commissioner, and process has been initiated to make the payment to the job card holders through the bank. And therefore seeks for 3 weeks' time to complete the process of payment. After hearing the learned counsel, after hearing the learned state council, it is ordered that on the next date fixed, the learned government advocate shall come with clear instructions as regard the payment made to the job card holders, failing which this court shall consider summoning the Deputy Commissioner personally to the court to explain as to why the funds has not been released to the beneficiaries listed after 3 weeks. Next time, you will come with proper instructions on payment.
For admission, item number 78.
Lordship, as he has been called by the last order.
There was some withdrawal. There was some withdrawal of the case.
Earlier.
However, the same LCR is recorded in the present case. But the LCR has been received. Okay. Yes, LCR has been received.
Okay, Lordship, in that case, this is for admission hearing, Lordship.
Yes. I will fix it for hearing.
It can be done today, Lordship. We are ready for hearing.
This is criminal revision.
No, civil.
Civil.
Well, criminal revision has been registered.
What is civil?
If this is mentioned, criminal revision. Just tell them to take care. So listen for hearing since LCR has been received. Yes.
Otherwise, we are repeating.
Or it can be heard also.
What is the matter?
It's a matter about this petition is filed against an order passed by the Assistant to Deputy Commissioner.
Ah.
Now, initially, the Congress of Kohima village passed an order in favor of the present appellant. Now, being not satisfied with that one, the present petitioners submitted an application to Deputy Commissioners, simply saying that they are not satisfied with the order passed by the Ramburas, GPs. The matter was referred to the DC, referred the matter to PA to DC. Now, PA to DC again referred the matter to the Bushes.
Is it permissible?
Not permissible, not at all. And so the Bushes took up the case as if it is a fresh case. So, against the order, the present respondent filed an appeal before the Assistant to Deputy Commissioner. Of course, addressed to DC, but it's endorsed to Assistant to Deputy Commissioner. So the order of the Assistant Deputy Commissioner is that since the Bushes has no jurisdiction, and since the application says review, that case was dismissed.
By Assistant to DC?
By Assistant to DC. Now, against that order, the present appellant has approached this court.
Assistant to DC judicial officers?
No, from executive side.
Okay, okay. So the problem starts with the endorsement of the case by PA to DC?
Yes. PA to DC is not Assistant to DC. It is not even a court.
Yes.
So, under what circumstances he can refer the matter to the Bushes? It is.
So against the order passed by the Deputy Commissioner, you have actually filed a case, you filed a petition before the Assistant to Deputy Commissioner?
Yes.
And Assistant to Deputy Commissioner has stated that the Deputy Commissioner, the Bushes have no jurisdiction?
No. Yes, that was the order.
Yes. So you take recourse, proper recourse. What is the proper recourse for you available in law?
By present revision. Since appeal has been filed before Deputy Commissioner and that was decided by the Assistant to Deputy Commissioner under Rule 31 of the Rules for Administrations of Justice and Police Nagam. Whether that rules have been complied by the Assistant to Deputy Commissioner while deciding this issue, this is the issue before this court. For that reason, I have come before this court.
Your Lordship, if we are to go by the rules, because my friend is insisting to follow the rules. In that case, under the rules, there is an appeal provision. And the appeal has to state certain facts and the grounds of appeal. Now, whether the present appellant has complied with that one, when they filed an application to Deputy Commissioner, It was not done. So from the beginning, from the inception, if they have not followed the rules, now they're insisting for following the rule by the court, but they have not followed the rule from the beginning. Secondly, let us assume that the present appellant has filed an appeal before the deputy commissioner, and then the matter was endorsed to the Dubashis. Now there are three things. Whether the Dubashis has got the appellate jurisdiction, one. And since their application says review, whether the Dubashis can review an order passed by the Gamburas. Says that one. If the application is taken as a fresh case, and in the case, the question of res judicata will come in because the Gamburas have already passed an order, and the Dubashis cannot take up the same subject matter. So either way, the DBS has no jurisdiction. And if the DBS has no jurisdiction, any order, howsoever good and sound, it is null and void. Now my friend is insisting that under Rule 31, if an appeal is filed before the deputy deputy commissioner or assistant to deputy commissioner, then the matter is to be tried de novo if the court feels that it is not just. Now, in that aspect, we have to see whether the Dubashis have passed an order having jurisdiction or not. If the Dubashis court have no jurisdiction, there is no question of considering whether this decision is just or not. Because it is null and void.
Void ab initio. Void ab initio.
Yes. So,
do you really want to hear the matter?
I'm ready, Lordship.
Welcome. Start.
Lordship. Lordship, the subject matter in the present case pertains to the disputed land. Lordship, I'm aggrieved by the decision passed by the Assistant to Deputy Commissioner, who is also the SDO's Sub-Divisional Officer Civil. Page 60, Lordship. May I take Lordship? Page 60. It's 3 pages, but Lordship, I may be allowed to read.
Whether there's Mr. Iralu, whether there's SDO Civil has been designated as assistant
yes,
of this.
yes.
Okay.
No dispute.
Very good.
No dispute.
Okay, this is page 60.
I may be allowed to read, Lordship.
Yes.
Lordship, a suit, Civil Appeal number 2 of 2019. Then applicant and respondent. Judgment and order. The fact of the case is that appellant in-law Solo bought a plot of land owned jointly by 3 grandfathers, namely late Willie Solo, late Funi Solo, and late Niville Solo. After their death, the land was jointly owned by their descendants. At the behest of the descendants of the 3 late grandfathers, the appellant bought the plot of land on 30th 9/2007. He made the same agreement deed signed by one descendant representing each of the 3 late grandfathers in 2008 to 2009. The appellant made some development in this plot of land as per government contract for strengthening of the road, but only in 2013. The respondent, Kevison Nazatsu and party, told appellant that he had bought the plot of land from V. Ketulia Solo, one of the descendants and grandson of late Velulia Solo. Sometime again, 2016, when the appellant and the respondents made near a plot of land, the respondent again told the appellant that he had bought the land by pointing towards it. On both the occasions, the appellant had told the respondent to approach his vendor and settle the matter amongst themselves. When the appellant started his work around 2018 in the plot of land, the respondent again disputed the ownership of the plot of land and filed a complaint before the Gambura's court, Kohima village. The complaint before the GB's court, Kohima village, was based on an unregistered affidavit, sale-deed agreement dated 28 to 2007 for the plot of land bought from Mr. V. Ketulia Solo, measuring an area of 120 into 68 square feet. The GB's court heard the parties and passed the order dated 8/6/2019 that Mr. V. Ketulia Solo, who had sold the plot of land to give another equal measure of plot of land to the present respondent, or shall pay back a principal amount with interest of 12 years amounting to 4,75,600 to the present respondent. Agreed by the order passed by the GB's court of Kohima village, the present respondent filed a review application praying for reviewing of judgment ordered by Gambura's court, Kohima village, before the Deputy Commissioner Kohima. The additional Deputy Commissioner Kohima referred the review application to PAA to DC, assistant to DC, who further referred it to the Dubash's court, Kohima. This is important, Lordship. In the GB's court, the order passed by the GB's court.
Let us read this. Aggrieved by
Lordship.
Let us read slowly.
Yes, Lordship. Aggrieved by the order passed by the GB's court of Kohima village, the present respondents.
You are the present respondent.
Lordship. File a review application praying for reviewing of judgment ordered by Gambura court, Kohima village, before the Deputy Commissioner Kohima. The additional Deputy Commissioner Kohima referred the review application to the PAA to DC, assistant to DC, who further referred it to the Dubash's court, Kohima.
Okay.
Next. In the GB's court, the order passed by the GB's court of Kohima village was reversed, and the present respondent in this appeal petition was made the owner of the disputed plot of land by order dated 12/9/2019 in poll case number 7/2019. Hence this appeal, under Rule 31 of the Rules for Administrations of Justice and Police, as amended from time to time by the present appellant. Files put up and heard learned counsel, as well as perused the written statement filed by the parties. The review order of the DP's court Kohima in poll case number 7 of 2019, dated 12/9/2019, is quashed and set aside on the following grounds, Lordship. This is important. On the following grounds, Lordship, the grounds, number one, the sale of joint property by a single individual and descendants like in the present instance of Mr. Vigetulia Solo and the respondent is paid in law. Hence, the sale of the plot of land by the vendor to the present respondent is void from the very beginning. Number two, the claim of the present respondent is hit by latches. There was no complaint from respondent when appellant carried out development works in 2008 to 2009, but only in 2013. The plot of land bought by the present respondent is measured at 120 into 68 square feet without any demarcation. This plot of land could be in any part of Buckland, Kohima, which without defined boundaries, this court is not inclined to acknowledge in the interest of natural justice and fairness to all concerned. Then Rule 31 of the Rules for Administrations of Justice and Police in Nagaland State. An appeal shall lie from the decisions of the Mausada, Gaumbura, Chief Headmans of Kales, Dubashis, or other duly registered village authorities to the tribal court, whenever constituted or otherwise, to the Deputy Commissioner or his assistant. If the court sees reasons to doubt the justice of the decision, it will try the cases de novo or refer it to the Panchayat as above. This is important. Lordship, on this ground I am coming. There is no provision for review of judgment or the decisions of lower court made in Rule 31. The review or the decisions of the DB's court, Kohima, is barred by the principle of coram non judice, which in the instant case, the DB's court, Kohima, cannot derive jurisdictions apart from the statute of the rules for administrations for justice and police in Nagaland. The DB's court had neither availed the provision of trying the case de novo or refer it to Panchayat. So, Lordship, this is the case. Then the next page, page
just read the last.
Yes, Lordship.
Just read the last.
Yes, Lordship. Therefore, Lordship, may I read it again? Therefore, there is no provision for review of judgment or the decision of lower court made in this Rule 31. The review or the decisions of the DB's court, Kohima, is barred by the principle of coram non judice, which in the instant case, the DB's court, Kohima, cannot derive jurisdictions apart from the statute of the rules for administration for justice and police in Nagaland. The DB's court had neither availed the provisions of trying the case de novo or refer it to a Panchayat. Page 62. Number 5. Rule
Just wait.
Yes, Lord.
Just wait. There is no provision for review of judgment order decision of lower court made in this Rule 31, correct? The review order decision of the is barred by the principle of coram non judice, which in the instant case, the DB's court, Kohima, cannot derive jurisdiction apart from the statute of the rules for administration of justice and police in Nagaland.
Yes. So since this decision was passed under Rule 31,
there is nothing wrong with this order.
Lordship.
When the assistant to DC says that you have no jurisdiction?
No jurisdiction, but he entertained under Rule 31. So whether this has been complied, Lordship, later on I'll come to it. Then, Lordship, paragraph 5, page 62, continuation. Rule 23A of the Rules for Administrations of Justice and Police in Nagaland states, the Dubashis henceforward shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or Additional Deputy Commissioner or Assistant to Deputy Commissioner as the case may be. The application to the Deputy Commissioner was for a review of judgment order passed by the GB's Court of Kohima Village and not an appeal petition under the relevant rules of the rules for administrations of justice and police in Nagaland. Since there is no provisions for review of judgment order under the rules for administrations of justice and police in Nagaland, the review order decision of the Dubashis court is null and void. The review order is also barred by the principle of res judicata, as the same matter has been adjudicated twice at different courts the DB's Court Kohima and the GB's Court of Kohima Village. Rule 35 of the Rules for Administrations of Justice and Police in Nagaland provides the High Court and the Court of the Deputy Commissioner and his assistants shall be guided by the Spirit, but not be bound by the letter of the Code of Civil Court. The review order of the DB's Court, Kohima, is also barred by the non-joinder of necessary parties to the case because the landowners, the plural of land to both the parties, appellant and the respondents, were not included in the review proceeding before the DB's Court, Kohima. Judgment order pronounced in presence of both parties in open court.
Are you agreed by this order?
Yes, Lordship. Lordship. Since Lordship, then coming to before going into to substantiate my claim, Lordship, may I take your Lordship to
Please take me to the genesis of the case.
Yes, Lordship.
How actually the case arose.
Lordship.
Please just give me the gist.
That dispute in 2007, the present petitioner purchased a plot of land at Darkland, Kohima. And then in the same year, Lordship, and all these are part of records, Lordship. In the same year, 2007, after us, again the present respondents, they also purchased the same plot of land from the other members, other family members of the landowners, Lordship. Same plot of land. Since the dispute arose out of that disputed land, the matter was, we filed a complaint before the GBs of Kohima Village.
Yes, sweet. You first filed a complaint before the GBs of Kohima Village.
Lordship.
Okay, then
the GBs decided our issue. The Lordship will find in page 18.
No, in whose favor? Just give me I'll hear you afterwards. Okay. Just give me the gist.
Then Lordship, neither in their favor nor in our favor. They have recognized our purchase. They have recognized by going the decision, because the GBs, they have decided in a way that yes, the person who sold the land to the petitioner has to give the equal portion of land to the person, to us. That was the decision. If he failed to do that, he has to pay 4,75,60,000.
So it was basically in your favor.
In a way, but we were agreed by this. Because we want, on what ground we can be ousted? How can? That is the thing, from that land. So Lordship, and so that is the decision passed by the Kohima Village, GB's court.
GB's order was in whose favor, as per you?
Recognize our purchase, whereas, see, we are agreed by this. We have not accepted. We are agreed by the decision.
Okay.
Yes.
So you were agreed by the decision of GB's order?
Yes, Lordship.
Okay, so
we filed one application before the Deputy Commissioner, being aggrieved by the decisions.
Application for what?
Application to review the judgment order passed by the GB's court, Kohima Village.
Okay.
Then the deputy commissioner again referred the matter to the PA to DC
Okay.
by the deputy commissioner himself. This is also reflected in the impugned order. Which was further referred to the Dubashi squad by the PA to DC.
Yes.
Then all the parties on summoned, all the parties they appeared and contested before the before the Dubashi's court. All the parties.
Then
the present petitioner as well as the
DBs decided in favor of whom?
Again, DBs on after verifications of the sport, they have decided in my favor, Lordship.
Yes, then
agrees by the decisions of the DB squad, the present respondent had filed appeal before the Deputy Commissioner again. Before the Deputy Commissioner. Under Rule 31 of the Rules for Administrations of Justice and Police in Nagaland. Then the impugned order has been passed.
Then DC had endorsed the matter to assistant to DC again.
Lordship.
Mr. Irabu, I think the Deputy Commissioner ought to have disposed the petition filed by the petitioner against the GB's order. I think the Deputy Commissioner should have taken recourse to that action.
In a way, of course, because that application has come to him.
And irrespective of whether, you cannot expect a common man, a layman, to actually know what is review, what is appeal. So they must have actually like written in the form of an appeal, a review. So Deputy Commissioner, instead of endorsing the matter to PA to DC and PA to DC, instead of endorsing the matter to the Dubashis Court, I think Deputy Commissioner should have taken recourse on the application under under Rule 31. Disposed.
Of course, it should have. Because for appeal or for any revision, whatever, there's no provision for reference.
So
to a lower court. And the appeal can be filed to DC or the assistant to.
And you are right when you say that actually the Dubashis could not have actually like taken up the case against the order passed by the village court.
No.
So it was ultimately the deputy commissioner who should have taken up the matter.
Yes.
And disposed of in accordance with Rule 31.
Yes.
Correct.
Yes. But the thing is now, of course, once the deputy commissioner takes up entertain the application filed by the present appellant, then of course we have also to file counter.
Of course. Yes.
And whether it has to be disposed of under Rule 31 or not, in terms of Rule 31 or not, that has to be examined by the first appellate court. But as of now, DB's court, under any circumstances, cannot sustain.
Yes, to that extent, I think yes, to that extent, because actually the whole problem in the case started with the Deputy Commissioner endorsing the case to PA to DC and PA to DC again re-endorsing the case to the Dubashis Court.
That is true.
So the whole procedure adopted is patently illegal.
Yes, it is illegal. That I agree.
Yes.
The peculiar thing.
Yes.
Peculiar thing in this case is, now the appellants, the present petitioners, they are claiming ownership on the basis of the affidavit, which the DB's court has relied, and they have enclosed the affidavit with their petition. Page 51. Now, this is a purported affidavit, sale deed agreement by the alleged purchasers. Now, if it is an affidavit, it has to be notarized or signed before a magistrate. Now, this is a testimony of the purchasers themselves, without any signature, without even mentioning the boundaries of the land, except 120 feet by 68 feet. This is the basis of their claim. Now, on the basis of such a document, how can one establish a title over a land? And therefore, the Gamburas have directed the purchaser, the seller, to return the money with interest, or to give an alternative site to the present appellants. And if, Your Lordship, if we are to proceed a case on the basis of this, then the present respondent, it amounts to harassment. Somewhere it has to come to an end. Now, if the Gamburas' decision was in their favor, they can get the money with interest or an alternative plan. So the Gambura's decision is, it's perfect. And on the basis of this, even if they go higher, on the basis of this so-called affidavit sale agreement, no court will take cognizance of this. And then where the appellant will go? Back to the process, well, Gambura's decision. Because this is nothing. This is only a self-made affidavit, without being notarized or without being signed by any magistrate. So if
Of course, as per the Registration Act, I think this does not carry any weight.
no,
Then, Lordship, what is the basis of this purchase, Lordship? What is the basis?
now the basis of our agreement is, after this agreement of sale, I was occupying the land, and I can use that agreement to prove my possession of the land.
And you are still in occupation?
Yes.
You are still in occupation?
Yes. Now, first was in 2000, I purchased in 2007, September. They alleged to have purchased in February 2007. But after purchase of the land in 2007, now in 2008, government proposed to revive the old road from hospital to Tinpati.
Correct.
Then, since there was a landslip area in my portion also, now the government proposed to raise a retaining wall. And being the landowner, I have constructed that retaining wall to protect the road. Then, thereafter, I started the first phase of my construction, raising the RCC pillars in 2009, sometime in 2009. Then they have no complaint. Then the second phase started. Then that was 2018. Then they complained. Only in 2018. Verbally they might be complaining. But after that in 2019, they lodged a complaint to the Gambura, Kohima village.
Just for my knowledge,
Yes.
both of you are the purchasers of the land.
Yes.
Both of you are the purchasers of the
Yes.
land.
The thing is,
And GB had directed which party to actually refund the money? To you or to the seller?
to the sellers. But in his case, now this land belongs to the grandfathers of three. Now, all these three grandfathers, this is their common property. So from each grandfather, we have to take permission. And as far as I'm concerned, I have taken permission from all these three. And so the agreement was signed by three of them. In his case, only one. That's why even the Gambura.
So, Mr. Iralu, the direction was given to whom to refund the money? With 12% interest?
To the seller,
Okay.
Viketule.
And that seller is willing to refund?
I don't know. It is, they have to pursue.
Saying that they have taken all the consents of all the three. We have prior to them.
Okay, let me now, go chronologically. Come to that, this Gambura's order.
Lord.
Which page?
Yes, Lord. Lordship, page 17, 16, starting from page 16. Then translated copy is in page 18.
Page 16, correct?
Page 16.
Yes.
Translated copy is in page 18.
This was
Gamburas.
this is a page. This is GB's order dated
GB's order dated 8/6/2019.
Please come to the translated portion.
Yes, Lordship, page 18.
Page
18.
18. Okay.
May I read, Lordship?
Yes, please.
Kevisin Nazatsu and party, that is the present petitioner.
Just wait.
Upon hearing both the parties and on verifying the land, Kevisin Nazatsu and party,
This Kevisin Nazatsu is
the petitioner, present petitioner.
Okay. And Vikatuli Solo is?
And Solo is the respondent.
No, it's not Vikatule.
Vic-
Respondent is Enlau.
You are Enlau.
Enlau.
You are Enlau.
Yes.
Or seller. The one who sold to us is Vikat.
Vikatule is the seller.
Seller.
To the present petitioners.
Okay.
Lordship, may I read?
Read, please read.
Upon hearing both the parties on verifying the land, Kevisin Nazatsu and party bought the land at Pechike, that land below the road, from Mr. Vikatulia Solo. But lineage of the three grandfathers had sold the land to N. Law. Therefore, Kohima Village GB Squad gives the following orders. Number 1, Vikatulia Solo and the descendants of his grandfather will give one piece of the land to Kevisena and party, either as per earlier agreement or more than that. Number 2, if the first order cannot be abided by, that they shall pay interest and principal for 12 years amounting to rupees 4,75,600 to Kevisena, Zatsu and party. If any party cannot abide by this order, they should adjudicate before any other court within the period of 1 month. So, Lordship, this is the decisions passed by the GBs. Lordship, here, one thing before we flip into the next stage. Here they have recognized that, okay, we purchased a land. Number 2, 12 years ago, that 12 years period that has been in our position, that was recognized by the GPs. Because 12 years amounting to the principal amount. Lordship, in a way, that is my interpretation.
They alleged to have purchased in 2007, and this was in 2019.
19.
That is why.
Yes. So, that is all.
Not in their possession.
Lordship, but see, just as per the decision, Lordship, as per the decisions. Then Lordship agrees by that, Lordship, coming to page 19. Agreed by this decision. I have submitted this application reviewing the judgment, Lordship, may I read?
Yes, read.
Page 19. To the Deputy Commissioner Kohima Nagaram. Subject prayer for reviewing the judgment order by GP's court, Kohima Village, with regard to land dispute at that land. HTK, Kohima with reference to Kevisin Nazatsu and party versus N. Lao Solo. Sir, with reference to the above cited subject, we would like to state these few lines for your kind consideration, that due to a land dispute as cited in the above subject, we approached the GB's court Kohima Village, where the court initiated the case on the 8th June 2019 and announced its judgment. However, we are dismayed and not satisfied with the judgment that was announced. We are therefore left with no option but to seek your office to review the judgment order of the GB's court Kohima Village and deliver a just and impartial judgment through the District Customary Court Kohima. We remain grateful to you for your kind and necessary action. Thanking you, yours sincerely. So this is by us again, Lordship. So in the footnote, Lordship, the endorsement. This is the endorsement below. PA to DC Kenizezo. So this is none other than, after verification, this is none other than the additional Deputy Commissioner Kohima, Lordship.
This PA to DC?
Yes.
This endorsement was done by ADC?
ADC, Additional Deputy Commissioner on verifications. Yes. Then, Lordship.
This bit?
Yes.
Then what about this head DB?
Yes, take up the case and disposed.
Who is
this? By the PA to DC to the head DB.
Okay, just wait.
Yes, Lordship. On the same day.
Yes.
So, Lordship, on endorsement, page 20 is the decisions passed by the DB's court.
Yes. Page
20.
Page 20.
Next 5, Lordship. They have registered as poll case number 7 of 2019 and dated 12 September 2019. This is a decision dated 12 September 2019.
Yes.
Then, Lordship, translated copy is in page 26. Lordship, this is little lengthy, but I may be allowed to read 2-page decisions. Page 26, Lordship.
Page 26.
Yes. How the parties have contested before the Devashish Court, Lordship. May I quickly read the Lordship?
Yes, which page?
Page 26.
Yes,
Lordship. Order given. Lordship, in poll case 7th of 2019. Order given. The parties to this case have both appeared before the DB's court on 27th August 2019. On hearing both the parties, it was learned through complainant Mr. Kevison Zatu, that is present petitioner, Lordship, party that the disputed land at Fecheke, that land was bought by him and his friend from Mr. Viketulia Solo, son of Le Keshotche Solo. Mr. Viketulia Solo's father, it. Keshotche Solo himself.
Late.
Father late.
Not
Lordship, sir. Keshotche Solo himself had demarcated the boundary line and gave it to us. At the time of purchasing the land, the elders belonging to the lineage of the 3 grandfathers had also agreed to it, and the written documents which has been submitted to the court is clear. Sometime later, me and my friend were offered to buy the remaining portion of land, to which we rejected. While this was so, Mr. Tenovilius Solo asked us to give the land we purchased to Mr. N. Law Solo. But since we refused to give, we were told to clear things up on our land. Therefore, Mr. Kejalehu Solo, son of N. Law, started work on the land we purchased. Hence, we filed a case before the Kohima village GB's court. But since we could not agree with the order, we brought the case before the DB's court, Kohima. Further, heard from Mr. N. Law Solo that the land situated at Darkland belonging to the lineage of the 3 grandfathers was bought by him on 30th September 2007 at rupees 80,000. The boundary line and the sale deed agreement submitted to the court is also clear. The landowners have also declared before the Kohima village GB's court that the land was given to Mr. N. Law Solo. Heard from the sailor Mr. Viketulia Solo that since the piece of land sold to Mr. Kevisen Zatsu and Mr. Kenil at Vacheke's Darkland is a common property, belonging to the lineage of the three grandfathers. He had consulted with the elders. One, Mr. Vishilya Solo, then number two, Nangaveya Solo, and number three, Keshotsehiya Solo, and sold the land to Mr. Kevisena Zatsu and his friend. Heard from Mr. Mipril Solo that before the land was sold to Mr. Anlaw Solo, there was no knowledge that the piece of land was sold to Mr. Kevisena Zatsu and friend. Next page, Lordship. Heard from Mr. Tinuvilius Solo that since Mr. Kevisena Zatsu and his friend had turned down the request to give the piece of land they bought to Mr. Anlaw Solo, they were asked to clear things up on their land. The Kohima DB's court had heard both the parties, but since it was difficult to pass the decision without inspecting the disputed land, on 12 September 2019, 8 DBs, along with both parties to the case, visited the place and the boundary line was shown to the DBs present there. After carefully observing the boundary line pointed out by both parties, the following orders are given. The court found that the sale deed agreement of both the parties is clear, and further, there are no complaints from the lineage of the three grandfathers. It is also found that the landowners knowingly sold the piece of land purchased by Kevisena Zatsu and friend to Mr. Anlaw Solo. It is also found that Mr. Tinuvilius Solo, landowner, while selling the remaining portion of the land to Mr. Anlaw Solo, had deceitfully sold the land which was already bought by Mr. Kevisena Zatsu and friend. It is found that Mr. Tinuvilius Solo knowingly and intentionally committed this act, which is wrong, and the dispute has also arisen because of him. Therefore, as per the earlier written agreement between the landowner and the buyer, the piece of land purchased by Mr. Kevisena and his friend shall belong to them. Also, the DBs who were deputed measured the piece of land purchased by Mr. Kevisena and his friend and found out that the land measured up to 104 feet length and 82 feet breadth, which shall be the boundary line between them and Mr. Anlaw Solo. Since Mr. Anlaw Solo had already undertaken some work on the land purchased by Mr. Kevisena Zatsu and friend, Mr. Kevisena Zatsu and friend will pay rupees 50,000 only to Mr. Anlaw to maintain peace and harmony. Any party who cannot abide by this order shall make a complaint to the sailors of the land. In this manner, the DBs who had deputed had passed this order, agreement signed. So this is the, again, decision rendered by the DBs court, a matter afresh, Lordship.
Then
So,
against this?
Against this appeal, page 29. Page 29. Appeal preferred by the present respondent before the Deputy Commissioner, and which is registered as Civil Appeal 2 of 2019. And interestingly, Lordship, the grounds taken against this
Oui.
Against this appeal memo, Lordship, we have filed detailed counter affidavit, page 63, Lordship. Annexed to my petition.
Page 63.
Page 63. This is the counter affidavit on behalf of the respondent. So if we go by the grounds and also read along with the counter affidavit, whether issues that has been raised by the respondent in that appeal has been taken into consideration, that issue is, but Lordship, since this is a civil revision, so I don't need to go in detail, but now the question of law that I wanted to bring before this court. But Lordship, since learned senior counsel has pointed out some agreement and the
Yes, on the question of law.
Lordship. But before that, Lordship, I may be allowed to just point out 2-3 documents. Just 2-3 documents. Page 48, Lordship. Quickly, page 48. This is the agreement by which they have purchased the land. And this is the basis of their case, Lordship.
Page?
Page 48. So they are questioning the validity of our sale deed. This is the agreement by which they have purchased the land. No area of land is mentioned.
And where is your agreement?
Lordship,
Where is your
agreement is in page 51, Lordship. Type copy is in page 52.
Page 51.
Yes, page 51. That Lordship, quickly along with that, page 53 and 54, this is very important, Lordship.
Okay, we'll resume at 2.
Oh, Lordship.
Resume at 2.
Chela Pak, is it
May I ask Lordships?
Yes, please.
Lordship may be gracious enough to allow something to mention, Lordship. From the hearing list, if you may pass over for the 114, for the private respondent number 5.
Item
114.
on the prayer of Mr. Fusako, Learned Counsel for the petitioner.
Number 5, Lordship.
Learned Counsel for the respondent number 5, listed after a week.
Lordship.
Please, Your Lordship.
Yes.
May I please mention item number 80?
80.
Your Lordship, I'm mentioning on behalf of the council for the respondent number 4, private respondent. Kindly allow 2 weeks to file affidavit in opposition.
Respondent number 4.
Yes, Your Lordship.
You are for the respondent number 4?
Yes, Your Lordship.
MS V. Tere. 6 for 2 weeks' time to file affidavit in opposition. MS Tere, sorry, Learned Counsel for the respondent number?
4.
4. 6 for 2 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 2 weeks.
In Your Lordship, item number 81. Here, Your Lordship, pleadings are completed, so it may be listed for hearing.
What is this IA for? IA 81?
Firstly, to make any fresh appointments in the Department of Directorate of Health and Family.
So we listed together?
Yes, Your Lordship.
Item?
Item number 81.
81. On the prayer of Miss Vetere, list the case after 2 weeks. Okay?
And Your Lordship, item number 110, 110. Here, Your Lordship, I have instructions to appear for respondent number 6. 110.
Okay.
I have instruction to appear for respondent number 6 and HID0.
Okay.
So, Your Lordship, kindly allow me 2 weeks to file my counter affidavit if necessary and to file my Pakalapima.
MS V. Tere, the Learned Counsel submits that he has been engaged to represent the respondent number 6 and therefore 6 for 2 weeks' time to file power and affidavit in opposition if so advised, listed after 2 weeks.
May I please, Lordship?
Yes, please.
My Lord, I beg to mention item number 84, my Lord. My Lord, if this can be passed over for the day.
No, first.
But if here, additional Advocate General MD Sumi is appearing, however, he is not here in the court today, so if this can be taken up tomorrow.
So we'll list it after a week, not tomorrow. Tomorrow we have some interview on the prayer of Mr. Takakichu, Learned Counsel for the petitioner, listed after a week.
Bless me.
Lordship, I beg to mention item number 109. Here, state is here to file affidavit, so can you grant me 3 weeks' time?
MSIME, the Learned Government Advocate, 6 for 2 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 2 weeks.
Your Lordship, hearing item number 127 on behalf of Sepong Chang, can you let the matter come up after 3 weeks? 127.
127. The Learned Government Advocate, 6 for adjournment. 6 adjournment of the case for 2 weeks. Prayer is allowed, listed after 2 weeks.
Much obliged.
May I please, Your Lordship,
Lordship, with the consent of both the parties, I'd like to mention item number 135 from supplementary cost list. Kindly grant us 1 week, Lordship.
Yes, Mr. Oh, yes. On the prayer of the learned counsel for the parties, listed after a week. Okay.
Much obliged.
Please, Your Lordship.
Yes.
May we please to mention item number 91 to 105, Your Lordship.
91 to
91 to 105. Here, sorry, 107.
91, 91, 90,
107.
91 to
107.
107.
Your Lordship, here in some of the writ petition, I have received the powers government. Some I have not received. So another 3 weeks will be granted.
MS Divika, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
Much obliged.
May I please, Lordship? Lordship, I have instruction to mention hearing item number 119 to 121.
119
to 121 analogous matters on behalf of KV Nagi. Lordship, the council is indisposed, so let the matter come
119 to
121.
121.
Lordship, let the matter come up on the 21st of September.
Mr. Senso makes a mention on behalf of Mr. KV Nagi and seeks adjournment of the case after.
Lordship, I'll kindly fix it on 21st of September.
Seeks adjournment of the case on 21/9/2023. Prayer is allowed, listed accordingly.
Lordship, there is also an interim.
The interim order passed earlier shall continue till the next returnable date.
Lordship, I would like to mention hearing item number 129 also. On behalf of my senior Mohd Jamir, counsel for the respondent number 5. Lordship, kindly let the matter come up after 2 weeks.
Mohd Jamir, respondent.
Yes, Lord. Respondent number 5.
Mr. Senso makes a mention on behalf of Mr. Mohd Jamir, the learned counsel for the respondent number 5, and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed after 2 weeks.
Your pleasure.
Your Lordship, on behalf of V. Socrates, I'd like to mention item 86, 87, 89. Pray for 4 weeks.
'86 to '89.
Yes. For 4 weeks.
Your Lordship, your necessary orders is required and it may be come up as per this. Your Lordship, this petition has been reverted back by the division bench.
Okay.
And fresh notice has to be served.
Okay. 86 to 89.
89.
Why fresh notice?
Your Lordship, here the writ petition was disposed of. However, the step has went for appeal, and then in the division bench, it has been reverted back to single bench.
So whether any private party is a
No,
party?
only state respondent.
So the state respondent is represented. Why notice? There is no requirement for notice.
Copies has to be served.
Who has to serve? You have to serve.
Yes, Your Lordship.
Okay.
And then the next one, Your Lordship, the item number 20, it's arising out of the above.
One by one. Where are you jumping? 86 to 89.
Yes, Your Lordship.
Okay. Let us see the record. 86 to 89. Okay. Heard MS Spencer, learned counsel for the petitioner. and Mr. So-and-so, on behalf of MSB Sokre, the learned Additional Advocate General, for the state respondents. Stop. The learned counsel for the petitioner shall serve the requisite copies of the writ petition to the learned state council within a period of
7 days.
within a period of 7 days from today, listed after 3 weeks. Okay. Okay.
Your
And
Lordship, in item number 90.
item 20, you were saying
90,
20,
90.
Okay. Item 90.
Yes, Your Lordship, here the COP arise after above writ petition,
Yes.
which has been quashed. And so may be allowed to withdraw this petition.
Let us see that order. No, let us see that this 80, 86, 87, 88. In view of the order passed in 86, 87, 88, na?
Yes, Your Lordship.
Read appeal.
Yes, Your Lordship.
MS so the learned counsel for the petitioner submits that in view of the order dated 24/8/2023, passed in WA 31/2022 and the other analogous writ appeals, the petition has become infructuous. The petition is accordingly closed as infructuous. Okay.
Your Lordship, on behalf of Mohanchan, I'd like to mention item 82. We pray for 1 week's time to file counter affidavit.
The learned government advocate seeks for 2 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 2 weeks.
Your Lordship, also item number 90. We pray for
90?
Yes.
90 has been withdrawn. It has become infructuous.
Your Lordship, there's an interim in item number 82.
82. The interim order passed earlier shall continue till the next returnable date.
Much obliged.
What is this? Oh, this is it's,
Lordship, before taking Lordship to the grounds why the instant revision petition is filed, there's one fact, page 53, while going through the title of the documents and how the land and also how the land has been purchased. Page 53. Lordship, page 53 is the land ownership certificate issued by the Kohima Village Council.
To whom?
To the present petitioners. Lordship, though they may not have the absolute authority to issue any land ownership certificate, however, to substantiate the claim, Lordship, here, the members belong to Zatsunumie TK, belongs to Zatsunuma TK of Kohima village. So it was issued by and signed by the chairman, Zatsunumie Khel Council, and also that was authenticated by the chairman, Kohima Village Council. Lordship, this is since all the parties belong to the TKL of Kohima village, this land ownership certificate has been issued in their favor. And this was filed when appeal was filed.
What are your grounds? What are your grounds?
Lordship.
Legal grounds?
Yes, Lordship. Page 8, starting from page 8 of my petition, Lordship. The first grounds taken.
Just wait. Page 8.
Page 8, Lordship. Yes. A, 4A.
Yes, please.
Yes, so Lordship, this is on the provisions of the rules, how the Assistant Deputy Commissioner can decide any appeal. Lordship, may I take your Lordship to the rules for administrations of justice, that Rule 31, Lordship. Rule 31. May I read for all of us, Lordship?
Yes.
An appeal shall lie from the decisions of the Mohzada, Gaumbura, Chief, Headman of Kale, Dobashis, or other duly recognized village authority to the tribal court whenever constituted or otherwise, to the Deputy Commissioner or his assistant. A record shall be made of the matter in dispute and the decisions of the village authorities. If necessary, the court shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as one of its own. If the court sees reasons to doubt the justice of the decision, it will try the case as de novo or refer it to a panchayat as above. Lordship, by the present impugned decisions which is under challenge, the Assistant Deputy Commissioner has quashed and set aside the decision passed by the Dubashis court. Whereas by the provisions, he has not followed into the provisions because the provision says that if that decision appears to be just, shall reaffirm and enforce is at one of its own. If the court sees reasons to doubt the justice of the decision, it will try the cases.
Mr. Krimole.
Yes, Lordship.
Whether it will be necessary to follow the provision.
Yes, Lordship.
When the DBS court has decided the matter without jurisdiction.
But Lordship, this matter has been filed under Rule 31.
Yes, what is your next ground?
Lordship. Then the next ground is the initially agreed by the B, Lordship. Yes, B. The present petitioner, being aggrieved by the decisions of the GP's court of Kohima village, they have submitted an application saying reviewing to the Deputy Commissioner, submitted to the Deputy Commissioner. Deputy Commissioner himself, he had referred the matter, rightly or wrongly, that was referred to the PA to DC, then further referred to the Dubashis court to decide the issue. Later on, when the matter was decided and by participations of both the parties voluntarily and without contesting the jurisdictions of the DB's court, after unsuccessful in that decisions, they have brought another appeal before the Deputy Commissioner. The same authority, the Deputy Commissioner Kohima. Then the Deputy Commissioner, the same authority, knowingly, he had referred the matter to the Assistant Deputy Commissioner to decide the issue. So, the same authority had a contradictory view, Lordship decision. This is one issue, that the same authority cannot have the contradictory authority or take up the adjudicated matter of the same subject matter, Lordship. That is the second ground, Lordship.
You kindly satisfy this court
Yes, Lordship.
as to whether the endorsement, okay, the endorsement was from the decision of the GB's court to DC,
Yes.
the appeal.
Yes,
For that matter, the review. Will it not stop there? Under Rule 31,
Yes, Lordship.
it was like for the deputy commissioner to have actually adjudicated as to whether the decision passed by GB's court was right or wrong.
Yes, deputy commissioner, he himself has to adjudicate the matter.
Yes.
But that was endorsed to the political assistant to deputy commissioner, and thereafter a political assistant to the deputy commissioner, the Dubash's court. It was not done by us. We approached the deputy commissioner. Whereas that on the reference that we had to appear before the Dubash's court.
So all the orders passed by the other authorities, leaving aside the deputy commissioner, is void. The order passed by assistant to the assistant to deputy commissioner, the order passed by political assistant to deputy commissioner first, the order passed by Dubash's court,
yes.
The order passed by assistant to DC.
Yes.
All these are void orders.
Well, Lordship, I can say, I'm fairly admitting that Dubash's court have no appellate jurisdictions to entertain any decisions. That was already decided by some the GBs of the Kohima village. I admit to that effect.
Yes, and actually even the PA to DC has no power to endorse.
No.
From Dubash's court, appeal was made to DC.
Yes, yes.
And DC endorsed the matter to assistant to DC.
Yes, Lordship. Lordship. So the same authority.
But still, everything has to go. Except, I think you will have to start from the application which is submitted to the deputy commissioner. Yes, giving you all the liberty to file a written objection. I think we have to take that recourse. If not, actually, like one authority sitting over an illegal decision,
Yes.
the next authority again sitting over that illegal decision.
Yes.
I think everything.
As far as the decision of the assistant deputy commissioner is concerned, there is no illegality because although initially we have filed the application addressed to the deputy commissioner against the order passed by the Dubashis, now that was endorsed to assistant to deputy commissioner.
That's exactly what I'm saying.
So that is
The assistant to deputy commissioner
yes.
has adjudicated over a matter decided by the decided by the DB's court without jurisdiction.
No. No, appeal lies from the decision of the village level or DBs to deputy commissioner or assistant to deputy commissioner or external. Both. So the present impugned order was passed by the Dubash's court, and under Rule 31, we filed an appeal before the deputy commissioner, which was endorsed to assistant to deputy commissioner.
That is exactly what I'm saying.
There is not wrong in that.
That is exactly what I'm saying. The order passed by Dubash's court
Yes.
was without jurisdiction.
Yes.
Therefore, where is the question of appealing against the DB's court?
No, but that is passed by the Dubash's court.
No, that is passed by DB's
Passed
court
by the Dubash's court.
without jurisdiction. I think we have to take that into consideration.
No, it is same. It is same because any court pass an order having no jurisdiction. Now, if we are not to appeal under the available provisions of the rules, then where the party will go? So even if the first court which passed the order has no jurisdiction, now the aggrieved party has the remedy to file an appeal under Rule 31. Otherwise, since the DBS court lacks jurisdiction and the order is in nullity, now if the aggrieved party does not avail the remedy of appeal, that order will stand forever. And the only option is to avail appeal under the available provisions of the rules, which is Deputy Commissioner or Assistant to Deputy Commissioner. And that we did. And Assistant Deputy Commissioner found that this DBS court has no jurisdiction. It lacks jurisdiction. So there is nothing wrong in that. What is wrong is an application was filed to Deputy Commissioner against an order passed by the Umbrella. The Deputy Commissioner endorsed it to PA to DC, which is a nobody.
Yes.
PA to DC endorsed it to Dubashir, having no jurisdiction. But as far as my appeal from Dubashir's court to Assistant to Deputy Commissioner, there is no illegality. Because the nullity of a judgment can be raised even in the appellate stage. That the Supreme Court has.
No, that is clear. That is the laid down principle of law.
Yes, Your Worship. So the procedure adopted by the Deputy Commissioner may be wrong. Subsequently, now appeal to the Assistant Deputy Commissioner against the order passed by the Bashis, there is no illegality in that.
So if the petitioner is contemplating to file appeal against the order of the assistant to DC, suppose,
yes,
what is the form?
To DC, because it says Deputy Commissioner or the Assistant to DC. Now, against the order of the Assistant to DC, appeal is available under Rule 29(1). To the Deputy Commissioner against the decisions of any of his assistants.
Okay.
Against the
That is a Nagaland Code volume?
Volume 3.
That's in Nagaland
Rule
Code.
29(1).
Okay. Rule 29(1), correct?
So
just wait, let me trace out that rule.
Yes.
Rule 29. Where is that rule? Which is this?
In this blue book, authored by Z. Angame, you'll will see at page 33.
Whether the provision of the law is incorporated?
Yes.
Page 33.
Page 33. Rule 29(1). New Rule 29, 29(1). Amendment.
Page 33,
Oh,
correct?
sorry. I'm sorry.
No.
37.
Page 37?
Yes. I was looking at.
Yes. Okay, new rule 1984, an appeal shall lie to the Deputy Commissioner against the decision of any of his assistants.
Yes.
And to the High Court against the original decision of the Deputy.
Yes. So even in the present case, now since the appellants are against the decision of the Assistant to Deputy Commissioner, they have to approach the Deputy Commissioner under Rule 29(1).
Yes. Yes, Mr. Kakre.
Yes, Lord.
The law provides you with a ground to file appeal.
Lordship, if that is the case, if they feels that the Dubashis, at the instance of the decisions passed by the Dubashis court, the respondents, they ought to file revision, because see, if they have no provision, then why should they contest the issue? They did not do that. When that matter was
No, the assistant to DC had taken up the appeal, the case under Rule 31.
No, Rule 31. Rule 31.
So as per Rule 31, he has the authority to pass any decision?
No, Lordship, that I maybe disagree with the submissions. Because Lordship, in the first instance, the matter was more or less endorsed by the Deputy Commissioner himself. Whether Deputy Commissioner himself can endorse the same matter to the two different courts, that is the issue, Lordship.
He is challenging his own application.
Lordship, that was the matter that was before the Deputy Commissioner. So if that is the case, if he agrees by that,
No,
saying that we are not...
see, against, let me just get your case clear.
Lordship.
Against the judgment passed by this GB's court.
Yes, Lord.
You had filed a petition before the Deputy Commissioner.
Yes.
The Deputy Commissioner had endorsed the matter to Assistant to DC. Yes. Assistant to DC had endorsed the matter to DB's court.
Yes.
DB's court had decided the matter.
Yes, Lord.
Against that decision of the DB's court, the present respondent,
Yes.
they have appealed against that decision before the Deputy Commissioner's court. Correct?
Lordship.
And the Deputy Commissioner has endorsed the matter to the Assistant to Deputy Commissioner.
Assistant to Deputy Commissioner.
And the Assistant to Deputy Commissioner has decided the matter, and against which you are before this court.
Yes, Lordship. So we are coming under revision, that's our Lordship. We are coming under revisions.
No, when
we are not defending the decisions passed by
when
the
actually the law provides a provision for appeal.
Yes, Lordship.
Where is the question of filing a revision petition?
But Lordship, before that, before going into appeal, that before challenging the order passed by the Assistant to Deputy Commissioner, this court can kindly see the legality, how the matter has been passed. That it has to see to the first decision, Lordship. Not simply that, okay, you go on appeal.
Okay, just let us take it this way.
Yes.
After the Dubashi's court had passed the order.
Yes.
Okay.
Yes.
Let us assume that the petitioner has not taken the case before the Deputy Commissioner. And let us say that the petitioner has taken the matter straight to the Assistant to Deputy Commissioner.
Lordship. Lordship.
Whether there is any infirmity in that.
Lordship, before challenging the merit of the case, whether the court has to see the jurisdictions, earlier the court, whether there has a jurisdiction to entertain the issue, I think that has to be looking into. That's Lordship.
What Mr. Iralu, the senior counsel, has submitted is, I think he is right. Because he says that when Dubashi's court rightly or wrongly has decided the matter, and that matter has been appealed before Assistant to Deputy Commissioner by way of endorsement from Deputy Commissioner, then the Assistant to Deputy Commissioner can certainly look into the matter as to whether Dubashi's court has the jurisdiction or not. And if Dubashi's court has no jurisdiction, the matter is.
Then what happened to the Deputy Commissioner who has endorsed that?
That is why my first question I'm asking you, suppose assuming.
Yes.
Assuming.
Yes.
Assuming that actually like the petitioner being aggrieved by the order passed by Dubashi's court.
Yes.
Had directly appealed to Assistant to Deputy Commissioner. Whether there is any infirmity?
No, Lordship. Yes. If that the issue, the Dubashi's court taken up any original issue, original suit by the Dubashi's court, then under 31, before the Deputy Commissioner or Assistant to Deputy Commissioner, they can go under 31. Whereas by the present case, in the present case, the Dubashi's court, that issue was arising out of the decision passed by the, or the decision rendered by the GB's court. Then what happened to the GB's court, that decision? If that is the original suit, Lordship, I'm fully agree with you. But this is not original suit, arising out of some decision.
No, but I still feel that actually, since the Worcester Court has taken up the matter
Yes.
without jurisdiction, the order passed by Assistant to Deputy Commissioner in appeal is, I think there's nothing wrong.
Lordship, if that is the original issue, the original suit, decisions of the original suit, we are fully agree with. Then what happened to the decision rendered by the GP's court of Kohima village, Lordship, in that case?
That is a misconception.
No, Lordship.
Original.
What will be happen to the original decision,
Rule
Lordship?
31 did not say whether it is an original or not. It did not say. But in the present case, although it is alleged that the matter has come to the DB's court through the Rampura's decision, now the GB's court took up the matter as if it is a fresh case. They adduced evidence, they went for spot verification, everything. They have not made a whisper of the GB's court. So they have taken this as a totally new case. So if they have taken up this as a new case, then they are stopped by a principle of res judicata. This is what I'm saying.
That Lordship, in that view, in case if the Dubashi's decision is in their favor, and we challenge the Dubashi's decision and set aside by the Assistant Deputy Commissioner or Deputy Commissioner, then what will happen to the decisions which is agreed by the parties rendered by the GB's court of Kohima village? Because this is arising out of it. So we cannot say that, okay, since that taken afresh, so we cannot say that this is the original suit. This is arising out of somewhere, something.
Okay, continue.
Then, Lordship, the second ground, the same authority, the Deputy Commissioner, they endorsed all the matters and had a contradictory decisions. That is, then if now this Assistant to Deputy Commissioner who had took up entertained the appeal on the endorsement of the Deputy Commissioner. Lordship, what here I wanted to make a submission here. If the Deputy Commissioner or Assistant to Deputy Commissioner, while making endorsement, that instead of again passing the order null and void, they ought to return the application or appeal or review, whatever, and endorse to the proper forum for decisions. That was not done. Third point, Lordship, third ground. Before the Dubashi's court, the DB's court, Kohima, the respondent, the present respondent, they have voluntarily contested and adduced all the evidence, whatever possible, before the Dubashi's court. Only when they are unsuccessful in that contest, they have come back to file an appeal and questioning the jurisdiction. Jurisdiction.
Oh.
Yes. Then, Lordship, another ground. The appellate court, now they have, in fact, they have come to the issue of the adjudications of the appeal by the Dubashi's court. That means they have come to decide on the jurisdiction now, Lordship, appeal, in appeal. and by the appellate court, the jurisdictions, the appellate court adjudicate on the issue of the jurisdictions, whether that can be done.
Why not?
Because
Irrespective of whether the parties have submitted
yes
to the jurisdiction of a particular court.
Yes.
If that court does not have the jurisdiction,
yes,
any party is welcome to challenge that court.
They can come. They can come.
Yes.
Whether the appellate court, they can just go into it. That is one ground. Now, the next ground, we in appeal under 31, we file detailed objection by way of affidavit in opposition before the counter affidavit. We file before the Assistant Deputy Commissioner while adjudicating the appeal. Not even a single word of the contentions made by the respondent in the appeal. That was not taken into consideration. Not even a single word. Lordship, may I take your Lordship to that effect? Lordship, may I take your
Now,
Lordship?
where will all this submission lead us if the court is of the view that the Dubashi's court had no jurisdiction? Where do we go from there?
No, but Lordship, if that is the case, since we were on the endorsement of the Deputy Commissioner, only we come before the Lordship's court. On the endorsement. So at this, the second stage, that one cannot just assert one right, his right, saying that, okay, he has passed in my favor, against my favor. That cannot, Lordship. That cannot. First see that, okay, that first how it has come to it, that is important. So if we are to go by the appeal, then okay, then by the appellate court, Assistant Deputy Commissioner, whether he has fairly, he has adjudicated the matter. This is one issue, Lordship. So I'm coming to it only.
Mr. Ralu, there's just one confusion. What the petitioner submits is that the court of first instance is the GB's court. Correct?
Yes.
And the matter taken up by DB's court was by way of appeal.
Yes.
So whether actually the second appeal would lie before the assistant to DC, that is his contingent basically.
Yes. No, the thing is, first appeal, there is no question of first appeal. Because the Boston court has taken up the case.
See, let us just see the genesis. Against Gauhati's court,
Yes.
judgment, a review was filed.
Yes.
In other words, an appeal was filed.
Yes.
And that appeal, or for that matter, the review was endorsed to Dubashi's court.
Yes.
So the Dubashi's court, let us assume, has taken up that appeal
Yes.
or review.
Yes.
So rightly or wrongly, Dubashi's court has passed one judgment.
Yes.
Correct?
Yes.
And that matter was again taken up before the assistant to deputy commissioner.
Yes.
So the question also arises whether the assistant to deputy commissioner has the jurisdiction to take up second appeal.
No, there will not be a second appeal.
Okay.
Because as per the rules, decision of the DBs or other village authorities, it says. There is no question of first appeal or second appeal. And since the Dubashi's court has no appellate jurisdiction, we cannot even assume that this has been taken up by way of the appeal. Because even if they have taken up by way of the appeal, it lacks jurisdiction. The decision is null and void.
So that's why, from that point onwards, suppose assuming that the Dubashi's court has taken up the matter in appeal.
Yes.
Okay.
So the best thing is, now they have to raise specific grounds and file an appeal under Rule 29(1) against the decision of the assistant to DC. Not by way of revision. Because appeal provision is available under the rules. Even Supreme Court says that under 225, 227, when there is appeal provision, they cannot come under 227. Supreme Court has already laid out the principle also.
Okay, let us, you conclude. Let us hear you.
So since we are questioning and impugning the decision passed by the Assistant to Deputy Commissioner, Lordship, may I take your Lordship whether while passing the decision, the objections raised by the respondents was taken into consideration? That is one issue we wanted to.
That is no issue. That is no issue when the Dubashi's court does not have the jurisdiction. Just on the threshold. If actually a court has no jurisdiction, why go into all the merits? And why raise the merits?
Then I have to appeal in that case, in that view. I'll have to appeal against the decisions, which is against out of nowhere.
Because so far as the question of jurisdiction is concerned, I think when we enter that question,
yes,
it is not necessary for us to hover around the merit.
True.
It's just a wastage of time.
Lordship. So, Lordship, in that case, see...
So, Dubashi was in your favor, correct? Dubashi was in your favor. But
I'm not
in favor. Even GP's court are in his favor. There is no close anything. By abiding with the decision of the Congress.
He wants the land, not the money.
Yes.
Yes.
Simple as it is.
What then?
Yes. And who is the genuine bias? This is the issue.
Unless a person has
Yes.
a prima facie
Who is the genuine
right
bias?
to the property, he cannot.
And just because there are all three grandfathers,
there is no prima facie case.
Let us actually not enter into the merit, because I think we will have to dispose this case on low grounds. That is why I am not very interested in merit. I want you to satisfy me on low points.
what you've done in the first place, whether the assistant to deputy commissioner, just simple as it is. I'm not going into the other grounds. The issue decided by the assistant to deputy commissioner, Lordship, I'll take this Lordship to his explanation, Lordship, then page 61 of his decision, impute decision. Rule 31, he has explained. Under Rule 31, what is supposed to be done by the court? It is explained by him, Lordship. Rule 31 of the Rules for Administrations of Justice and Police in Nagaland states, an appeal shall lie from the decisions of the Mauzada, Gambaras, chief headmen of Kale, Dubashis, or other duly recognized village authority to the tribal court, whether constituted or otherwise, to the deputy commissioner or his assistant. If the court sees reasons to doubt the justice of the decision, he will try the case de novo or refer it to a panchayat as above. That is the provisions.
But here the question of referring the matter de novo does not arise because Dubashi's court has no jurisdiction. Where is the question? Where is the question of referring the matter back to Dubashi's court, which has no jurisdiction?
Then, Lordship, see, this is
So we have to go ahead instead of looking back.
No, but see, because this is 531, Lordship, 531. So if that is 531, then it has to be
under 31.
Yes, Lordship.
Whether actually the assistant deputy commissioner is preventing from taking a from making a decision that the Dubashi's court had no jurisdiction to try the case? Whether the assistant to DC is prevented from actually giving that finding?
No, but the grounds that, okay.
And if you are saying, if you are emphasizing on Rule 31, then for trying the case de novo, that means actually refer back to the court which has decided. Then the court which has decided has no jurisdiction.
Or refer it to Panchayat, of course, we don't have Panchayat in that lordship.
Yes, your next ground.
So lordship, that is the case at hand, that since whether fair trial or that the appeal has been, adjudications have been made in this case.
I think you are unnecessarily jumping into a wilderness and getting yourself confused.
No, but lordship in the first place, now lordship, if I can satisfy in that line.
You have not satisfied me on that.
Lordship, that is how, if I can. Since the matter originally decided, whether in their favor or in our favor, we oppose the Deputy Commissioner. Deputy Commissioner, if that, okay, he has no jurisdiction, Dubashi's court has no jurisdiction. Then in that case, he had to decide. But he sent us to somewhere, done it. Then again, when the second, that on appeal that was come, again that was also referred. So lordship, that is the only issue that I have. Yes, I have that one. Yes. That is my submission.
Yes.
Yes. So lordship, one submission is maybe recorded here. The decisions of the Assistant Deputy Commissioner, that was in fact ultra virus, because lordship, see nowhere that he can quash and set aside the decisions.
Okay.
Yes.
Yes, Mr. Rabi.
Now, I have nothing much to say.
You satisfy me on low points.
Only thing is that now, whether right or wrongly, an application has been filed before the Deputy Commissioner. This has processed, culminating to the order passed by the Deputy Commissioner. I'm sorry, Assistant Deputy Commissioner. So the application filed before the Deputy Commissioner at the first instance, that stage is already over. So there is no question of going back into the application presented before the Deputy Commissioner, praying for a review of the DB's order. That stage has already passed because after endorsing the method which reached the DB's court, from DB's court now appeal has come up. Therefore, there is no question of going back to the application filed before the Deputy Commissioner because that has already crossed. The stage has crossed. The only best option available to the present petitioner is to file an appeal, an appropriate appeal under Rule 929, one of the rules, challenging the order passed by the Assistant Deputy Commissioner. Now, from that stage, we have to continue if the petitioners want to further proceed with litigation. That is the only option. That is the only best option. Because as long as there is remedies available by way of the appeal, no revision lies under, even under Article 227 of the Constitution. It is what the Supreme Court says.
Do you have a citation?
Your Lordship.
Give me.
I have compiled a few citations. All may not be necessary, but
relevant ones.
relevant is the book list.
Yes,
First
just-
one is question on maintainability of revision petition when remedy by way of an appeal is available. This
Just wait, Mr. Rizal. Yes, yours is first is SSA 2017 online.
This is Gauhati.
Gauhati, oh.
Yeah,
oh.
our own High Court.
Online Gauhati, okay. Why 2017 SSC online Gauhati?
From this SCC online, we obtained. So we are giving that reference.
Okay.
And this is in the case of Sazole Angami versus Kavito. Relevant paragraph is paragraph 9.
Just let me see.
Paragraph 9.
2017 paragraph
9. Very Lordship.
Yes.
On cursory perusal of Rule 32 of the Rules for Administration of Justice and Police in Nagaland, Third Amendment Act, given above, particularly the proviso, it would be seen that any one of the parties aggrieved by the proceedings before any officer subordinated to the High Court or the DC can approach the High Court or the DC under such provision only after having availed the remedy by way of an appeal. As per Rule 31 of the same Act, read with Rule 2 of the Second Amendment Act of 1982 of the same Act, appeal lies against such decision of DB's court before DC or his assistant. Therefore, the petitioner, before coming to this court, under Rule 32 of the same Act.
Rule 32 is revisional jurisdiction?
Yes.
Okay.
32 of the same Act should have first exhausted the remedy available by way of appeal before the appellate court. However, since the petitioner has not exercised the remedy provided under the Act, which is the prerequisite as the proviso to Rule 32 for approaching this court, the petition of the petitioner is not maintainable. Then the second one is by SCC 2022. Para 17, 18, and 19.
Please read. 17, 18, 19, correct?
Yes.
So we'll give 17.
Muhammad Ali. 17, 18, and 19.
Yeah.
17. Even otherwise, and as observed herein above, against the ex parte judgment and decree, the remedy by way of an appeal before the first appellate court was available. Therefore, the High Court ought not to have entertained the revision application under Section 115 CPC and under Section 227 of the Constitution of India. The High Court ought not to have entertained such a revision application challenging the ex parte judgment and decree. Once there was a statutory alternative remedy by way of an appeal available to the defendants, the High Court ought not to have entertained a writ petition or revision application under Article 227 of the Constitution of India, 18. At this stage, the decision of this court in Virudu Nagar Hindu Nagardha Dharma versus so and so is required to be referred to in the said decision. It is observed and held by this court that whenever the proceedings are under the Code of Civil Procedure and the forum is the civil court, the availability of remedy under CPC will deter the High Court, and therefore the High Court shall not entertain the revision under Article 227 of the Constitution of India especially in the case where a specific remedy of appeal is provided under the CPC itself. While holding so, it is observed and held in paragraph 11 and 13 as under. Secondly, the High Court ought to have seen that when a remedy of appeal under Section 1041I, read with Order 43, Rule 1R of the Code of Civil Procedure, was directly available, the respondents 1 and 2 ought to have taken recourse to the same. It is true that that the availability of remedy of appeal may not always be a bar for the exercise of supervisory jurisdiction of the High Court. In so and so, this court held that though no hurdle can be put against the exercise of the constitutional powers of the High Court, it is well recognized principle, which gained principle judicial recognition, that the High Court should direct the party to avail himself to such remedies before he resorts to a constitutional remedy. 19 Erosion. Applying the law laid down by this court in the aforesaid decision to the facts of the case on hand, the High Court ought not to have entertained the revision petition under Article 227 of the Constitution of India against the ex parte judgment and decree passed by the learned trial court in view of the specific remedy of appeal as provided under the Code of Civil Procedure itself. Therefore, the High Court has committed a grave error in entertaining the revision petition under Article 227, challenging the ex parte judgment and decree passed by the learned trial court, and in quashing and setting aside the same in exercise of powers under Article 227 of the Constitution of India. So that is the rest of the citations, your Lordship is well aware. So I believe I did not go into the details.
Give me the para which you are relying in this Kohima bench.
Kohima bench, GLR, paragraph 23, within bracket 1. In the case of Alantim Jamir.
Let us read that paragraph 23(1).
Okay.
Let us just read.
23.
Yes.
Having discussed the points of reference, we now answer the issues of reference as under. The bosses cannot be empowered as appellate court by the exercise of powers under Rule 23A. Rule 31 debars DC ADCs and his assistants from such authority.
Yes.
That one is the relevant part. Then the other one is 2008 SEC, paragraph 25, 26, and 28.
Para 25,
26, 28. Paragraph 25.
Yes.
The court
25, 26, 28.
Yes.
Yes.
The court then proceeded to rely on so and so, and observe in paragraph 32 that neither consent nor waiver nor acquiescence can confer jurisdiction upon a court otherwise incompetent to try the suit. The court further observed that it is well settled and needs no authority that where a court takes upon itself to exercise a jurisdiction it does not possess, its decision amounts to nothing. A decree passed by a court having no jurisdiction is known as, and its invalidity can be set up whenever it is sought to be enforced as a foundation for a right, even at the stage of execution or in collateral proceedings. A decree passed by a court without jurisdiction is a quorum non judice. 26. The court also relied upon the decision in so and so and quoted, "It is a fundamental principle well established that the decree passed by a court without jurisdiction is a nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. A defect of jurisdiction strikes at the very authority of the court to pass any decree, and such a defect cannot be cured even by a consent of parties." And 28. Once the original decree itself has been held to be without jurisdiction and hid by the doctrine of coram non judice, there would be no question of upholding the same merely on the ground that the objection to the jurisdiction was not taken up at the initial first appellate or the second appellate stage. It must therefore be held that the civil court in this case had no jurisdiction to deal with the suit, and reluctantly the judgments of the trial court, the first appellate court, and the second appellate court are liable to be set aside for that reason alone, and the appeal is liable to be allowed. In view of this verdict of ours, we have deliberately not chosen to go into the other contentions based on merits. We, however, made it clear that we have not, in any manner, commented upon the rights of the respondent plaintiffs, if any, arising out of the labor jurisprudence. Then the next one is 2012 for SCC, paragraph 22. Yes. There can be no dispute regarding the settled legal proposition that conferment of jurisdiction is a legislative function, and it can neither be conferred with the consent of the parties nor by a superior court, and if the court passes order, decree, having no jurisdiction over the matter, it would amount to a nullity as the matter goes to the roots of the cause. Such an issue can be raised at any belated stage of the proceedings, including in appeal or execution. The findings of a court or tribunal becomes irrelevant and unenforceable, inexecutable once the forum is found to have no jurisdiction. Acquiescence of a party equally should not be permitted to defeat their legislative animation. The court cannot derive jurisdiction apart from the statute.
Correct.
And on question of PA to DC,
This WPC 2010,
yes,
which para?
paragraph 21. Paragraph 21.
Yes.
Going by the provisions as contained in rules and Rule 2C in particular, this court is of the considered opinion that the political assistant to the Deputy Commissioner is not vested with any judicial powers by the rules and therefore has no power to hear appeals against an order passed by the Bush's court. And the last one is 2002 GLT para 6. Para 6. Rule 31 of the Rules for Administration of Justice and Police in Naga Hills District provided that appeals shall lie from the decisions of the GBs, Chief, Headman of KEL, or any other duly recognized by village authorities to the Deputy Commissioner or his assistants. There is no provision for preferring an appeal to the TP's court against the decision of the village council, village court. The appeal lies with the deputy commissioner or his assistants. There is also no provision under the rules that appeal against DB's court shall lie with the political assistant to the deputy commissioner of the district. The political assistant, in fact, is not the court and has no authority to exercise a judicial power in the state. Therefore, the order passed by the DB's court as well as political assistant deputy commissioner are without jurisdiction and not tenable in law. So those are the few petitions which I would like to rely upon in connection with the present case. So the best option for the appellant is to file an appeal under Rule 29(1). That is my short and humble submission, Your Worship.
Yes, any reply?
Lordship, since...
That's on the question of law.
Yes, Lordship. Since, Lordship, the senior counsel has coming to invoke Rule 21A, 1 of the Rules for Administration's Lordship. Then we'll have to first understand, Lordship, whether this can be taken up. Lordship, may I take your Lordship to Rule 29? Rule 29. We'll have to first understand that. Yes.
Yes.
The Deputy Commissioner and his assistant shall not ordinarily hear suits triable by tribal court, Mausadas, Gamburas, chief headmen of Khels, Dubashis, or other duly recognized village authorities, but they have a discretion to do so when they think right, and suits which under these rules the village authorities and the tribal courts cannot try, must be tried by the Deputy Commissioner or his assistant. A register of all suits tried by the Deputy Commissioner and his assistant shall be kept in such form as the High Court shall direct. So, Lordship, now, since Senior Counsel has taken us to Rule 21, Clause 1.
Rule 21 or Rule 29?
29, Clause 1. My apology. Lordship, saying that appeal shall lie to the Deputy Commissioner against the decisions of his assistant. This is arising out of Rule 29. Because Rule 29, thereafter Rule 29(1). Lordship. So, matter which cannot be taken up.
No. What is wrong with Rule 29? Which actually empowers the Deputy Commissioner to take up appeal against the decision of his assistant?
No, 29(1.
Oh, 29(1) I'm reading.
But before that, we'll have to understand that Rule 29, which matter can be taken up by the assistant to Deputy Commissioner, Lordship. That has to be understood first. 29, Lordship. That's how I'm taking the Lordship to Rule 29. The Deputy Commissioner and his assistant, Lordship, shall not ordinarily, Lordship. That is how it has come, Rule 29(1) has come.
Even if you have no jurisdiction, the Deputy Commissioner or his assistant shall have no power to take up the matter in appeal.
But ordinarily, they are debarred to take any suits, Lordship here. Debarred, Lordship, by 29. Lordship, that may be also recorded, Lordship. That may be recorded. Then, Lordship, another contradictory view, so far that the question and setting aside the decisions passed by the Dubashis in in the case of Civil Review 5 of 2019, Lordship. That
What did the judgment read by Mr. Viralo, the senior counsel?
Yes, Lordship.
You cannot give jurisdiction to the court, even by your consent. That's why I was telling you, irrespective of whether the parties have participated before the Dubashi's court. Now you cannot take a plea that the parties have participated and therefore the question of jurisdiction doesn't, it is not that. Even if the parties with their consent has participated before the Dubashi's court, if actually Dubashi's court lacked jurisdiction, any party can raise that issue in appeal or even in execution proceedings. That is the law. So beyond that, you give me some citations of the Supreme Court.
No, Lordship,
which
I'm
goes
just
beyond
standing
that.
by the provisions here itself. Yes, by the provisions. But anyway, Lordship, if that is the view.
That is not my view. That is what the Supreme Court has said. And that is the law. Not my view. Is anything more?
No, that's all. Rule 29, Lordship, that may be. Yes.
Okay, it's all. You take it, okay? You take this also with the answer. Mr. Krimule, the learned counsel for the petitioner, and Mr. R. Iralu, the learned senior counsel for the respondent, assisted by M.S. So-and-so, learned counsel. Are the parties in line? Are the parties at line? Judgment and order reserved. Okay. Is there? Yes, come.
No, there are still many more.
Oh, good. Okay. I said that.
Resolution, item number 79.
Yes.
May I please, Lordship? I am appearing on behalf of my senior moderator. Lordship, I'll let this matter come of hearing after a week.
Hearing's complete.
Lordship, we would like to proceed without filing our counter.
Okay, we will record that. And that implies that you have admitted to all the statements made by the petitioner. Okay. And Ms. So-and-so, learned counsel for the petitioner, and Mr. So-and-so, learned counsel for the all the respondents.
Sole respondent.
For the sole respondents. Stop. Mr. So-and-so, the learned counsel for the sole respondent submits that it will not be necessary for the respondents to file their counter affidavit. List the case for hearing in the usual course.
For resolution, item number 83.
Yes, Mr. Anangami.
May I please, my lord?
Yes.
Lordship, the matter was listed on 22/8/2023. And Lordship, on that day, as per the order passed by this honorable court, on that 10.
22/8/2023. 23 years.
Lordship, as per the order passed by this court on 10/8/2023, I have placed a letter on this date.
Yes.
However, Your Lordship, the court has passed another order on the same day, that is 22/8/2023, directing me to obtain and place the concrete instruction today. And the matter is listed today, Your Lordship.
Okay.
Now, Your Lordship, I have received another letter from the department, if I may be allowed to place it on record, Your Lordship. And this letter, Your Lordship, Your Lordship, this is letter dated 22 August 2023. Now, this is a letter in reply to the clarification sought for by the department as to what date shall be counted for the promotions of the petitioner, Your Lordship. And the government has given its approval, Your Lordship, stating that, if I may be allowed to read the para, Your Lordship.
Yes.
With reference to the above cited subject and your letter number such and such dated 11 August 2023, this is the letter I have placed it before my Lord, Your Lordship. I am directed to inform you that in continuation of this office letter number such and such dated 27th September 2022, the effective date of upgradation in respect of the 20% of the FHW supervisor to FHW special grade and the subsequent upgradation promotion will be 13/6/2022.
The effective date for upgradation in respect of 20%.
Yes, Your Lordship.
What does that mean? 20%. So out of 100%, 20% are given promotion.
Yes, yes.
That is the policy.
That is the policy, Your Lordship. Now, the effective date will be from 13/6/2022.
But this is not in respect of us, Lordship.
Your Lordship, this actually, it applies for the other this thing also, Your Lordship. Not only for the petitioner. There are two grades, Your Lordship. There are two grades. One is, Your Lordship, grade one to FHW supervisor.
Yes.
And another one, Your Lordship, that is the petitioners, Your Lordship, is field health worker supervisor to FHW special grade. Now, both these, Your Lordship, both these, their effective date of promotion has not been given up to date, Your Lordship.
They're promoted?
Yes, they are promoted. They are promoted and the petitioner's promotion was kept on hold. Was kept on hold by a letter dated, Your Lordship, it is there in the writ petition, Your Lordship, by a letter dated 8th of July 2020.
Which page?
Page 31, my Lord.
To the writ petition.
To the writ petition, my Lord. Page 31. Now, Your Lordship, page 29 is actually the promotion given to the petitioner from grade 1 to FHW supervisor.
So this was put on hold?
Yes, this was put on hold, Your Lordship.
Have you filed your affidavit?
No, Your Lordship.
File your affidavit.
Lordship,
I was just asked to, yes.
Lordship, the reasons why I have the other day placed before this court, since these petitions are retiring day after tomorrow. So for that reason only, that instruction has to be sought. Because to let them also go peacefully, just because of that only, and since promotion has already made, the only thing is not taking effect of it. And they are not recalling the...
No, if this court feels that you are eligible for retrospective promotion, you get all your benefits.
Yes, Lordship, if there are that assurance on that.
No, Lordship, by this
because in what capacity we are going to be retired, Lordship? This is one issue. And 27 of them. And throughout our service career, only one promotion from the family health workers to grade 1. Thereafter, no promotion. This is the only promotion, and in 2020, since vacancy arose, with the approval of the PNR, then the concurrence of the finance, our promotion has been made. But again, subsequently, one letter has been put saying that no, the promotion be put on hold because they are higher ups. They are asking for again higher ups, the higher promotion, further promotion. For that only, our matter has been put on hold.
Because the higher ups, the next immediate higher post, they were not promoted.
Yes.
So you could not be promoted when they were
all
still
retired, now all retired.
No,
Lordship.
now it must have retired.
Yes.
But during that time,
Yes.
when the letter to put your promotion on hold was issued, your seniors were still not promoted. There was no vacancy, correct?
Yes.
No, Lordship, I have placed the record, Lordship.
Let him file a
Lordship, this annexer.
You file your affidavit. You file your affidavit. If you are entitled to promotion, retrospective or otherwise, you will get your benefit.
Yes, Your Lordship.
Lordship, in that case, that observation.
You are going tomorrow, day after tomorrow, so maybe it may not be proper for this court to now dispose without the affidavit of the government. Mr.
Lordship, in that case, see, let us also consider the sentiment of those people, the petition, because finally we have no other option. That is how we have come.
Mr. Kakre, you know that promotion is not a fundamental right. You cannot insist on the government to give you promotion. It is not a fundamental right. You have a right to be considered.
Yes, Lordship, but we have been, in that case, we have been
That is why I am saying, for the discrimination part, if you are entitled to promotion, this court will actually give an observation, and if actually any observation is given in your favor, you will get all retrospective benefits.
Correct.
Mr. Nangami, the learned senior government advocate, he is allowed 2 weeks' time,
Lordship,
to file affidavit in opposition. Listed after 2 weeks.
Lordship, since I have received only this particular page, if 3 weeks' time can be granted to me so that I can file a proper affidavit, Lordship.
Don't accumulate their liabilities.
No, Your Lordship.
3 weeks, okay, 3 weeks.
For admission,
I am deeply obliged, my Lord.
for admission, item number 85.
Please, Your Lordship.
Yes.
Your Lordship, the government are yet to file affidavit.
Oh. Item 85. Mr. Nangami, you are for the government. 85.
Lordship, the state respondent are represented by Mr. Tiba.
He is in bereavement, I am told.
Lordship.
Mr. Nangami, the learned senior government advocate, makes a mention on behalf of E. Tibapong and submits that Mr. E. Tibapong is in bereavement and therefore seeks adjournment of the case after 2 weeks. Prayer is allowed. This is the case after 2 weeks.
For hearing, item number 108.
Yes, ma'am.
108.
Please, Your Lordship. As per the last order, 2707/2022, interim is to be heard today. 07/2022, Your Lordship, in this writ petition.
Who are the parties?
But my senior is not here in court now, so may the matter be passed over for a day.
Lordship, this matter appears to be in the order column. So maybe, Lordship, the notice upon some respondents may not have been completed, my lord.
Whether this Lok Ayukta is a party?
Yes, Your Lordship, respondent number 4. We have filed our amended petition.
Whether affidavit in opposition has been filed?
No, Your Lordship.
You are for the government, Mr. Nangami?
Lordship, yes, S. Mary is actually handling the matter, Your Lordship.
Okay. But we don't know whether respondent number 4, respondent number 4 has just been implemented.
Lordship.
By order dated 18/8/2023.
Lordship.
Awaiting return service upon the respondent number 4, listed after 2 weeks.
Lordship.
For hearing, item numbers 111 to 113.
Yes,
May I please, Your Lordship?
yes.
Your Lordship, may this matter be passed over for a day, Your Lordship?
No buzzer work. No hearing tomorrow. Tomorrow we have some other work. What is the matter about, Mr. Nangami?
Your Lordship, in fact, WPC 88, Your Lordship, 88 of 2022. Here, what happened was the earlier, way back in 1970s, Your Lordship, the petitioner's father was given a special permit for cultivation on account of his the service rendered to the public by the government. So it was a government land actually. So the petitioner was father was given a special permit for cultivation, and in the meantime, Your Lordship, the petitioners started selling off the plot of land. All these things happened. People also have encroached, and moreover, because of the expansion of the township, the government also, because the land belongs to the government, so the government also has established certain government offices and all, Your Lordship. So there were some private parties also who the property has been sold off to, Your Lordship. There the dispute arose. So in other two petitions, Your Lordship, 58 of 2017 and 207 of 2016, here the petitioner are here before this court challenging the restraining orders issued by us to the petitioner. But, Your Lordship, in 88 of 2022, the court has directed the state government to constitute a committee, and that committee are supposed to take a decision after submitting its report to the chief secretary. The chief secretary, after getting the report from the committee, have cancelled the special permit that was given to the petitioner's father. So 88 of 2022 is a writ petition challenging that
cancellation
and also the committee report.
Okay. Due to paucity of that, the matter could not be heard. Listed after a week. Okay.
Obliged, madam.